And I will to order the 2014 Fall Town Meeting. Yeah, we're missing the selectmen, but I think we can muddle through. Please take your seats. I acknowledge the Constable's return of service relating to the proper publication and service of the warrant, and call on Dr. Slayton to lead us in the Star Spangled Banner.
Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming, and the rocket's red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say, does that star-spangled banner yet wave o'er the land of the free and the home of the brave?
Thank you, Dr. Slayton. I have my usual announcements. Please silence all cell phones and electronic devices. I remind you of our seating procedures. Only town meetings members may sit forward of the checkers tables except for the front row center, which is reserved for speakers and town staff. And the first two rows on my right are reserved for members of the press. Handicapped town meeting members may sit anywhere in the front row. I remind all speakers to announce your name and precinct as your first order of business when you present, and limit your remarks to 5 minutes unless you've made a prearrangement with me. Finally, please address questions to the moderator, should you have any. We will be taking the articles in the special town meeting in order with the following exceptions. We'll have a single debate for Articles 15 and 16, which relate to RMD clinics. Whoops. You know, I've spent the entire season here mixing up Articles 12 and 15, so I'll rely on you to keep me straight as we go through the meeting. When we reach 8 o'clock, we will finish whatever article we're engaged in at that point, and then proceed to the special town meeting, which is a single article. The article is replicated in a sense in Article 14, in the special town meeting, and I will accept a motion to advance Article 14 to be heard immediately after we conclude the special within the special after 8 o'clock. Would someone like to make that motion? A second? All those in favor of advancing Article 14 to be heard immediately after we dissolve the special town meeting within the special, please say aye. Aye. All those opposed, no. Motion carries. Dr. Vitolo is the petitioner under Article 11, and he moves that we postpone deliberation of Article 11 until first thing on Wednesday, and the reason for that is we will be hearing from 5 very busy Brookline High School peer leaders under that article, and this will give them cause the least disruption to their schedule. So on Dr. Vitolo's motion to consider Article 11, first thing Wednesday, is there a second? Those in favor, please say aye. Those opposed, no. That motion carries. Now we will have one quick dry run on electronic voting. The motion before you is resolve that Tom Brady is the best quarterback in the NFL. I remind you that the only buttons that are relevant in your voting are numbered 1, 2, and 3. 1 for yes, 2 for no, and 3 for an abstention. Go ahead and start the, okay, we've started the timing, so all those in favor of that resolution, please stand and press 1. Thank you. All those opposed to that resolution, please stand and press 2. And those abstaining can press 3 at any time. You can change your vote at any time. The motion carries by a vote of 100 in favor, 17 against, and 52 abstentions, about what I would have expected. We'll now proceed with the articles, and the first article is Article 1, relating to unpaid bills of past years. There being none before us, the motion is for no actions made by Mr. Franco and seconded by Mr. Bors. All those in favor of no action under Article 1, please say aye. Those opposed, no. Motion carries unanimously. Article 2. This is the collective bargaining article, and there are 2 motions being offered under Article 2 on page 2-18. The first relating to the Brookline Police Association contract, and the second at the bottom of page 2-18 relating to Teamsters Local 25. Those motions are moved by Ms. Daly and seconded by Mr. Bors. I call on our Human HR Director, Sandra DeBow, as customary, to explain these contracts to us. Ms. DeBow.
Good evening. My name is Sandra DeBow. I'm the Human Resources Director for the town. We have 2 police memorandums of agreement before us. One spans the fiscal years of 2012 to 2014, with increases of 1.52% in FY13 and 2% in FY14. These increases are in line with what the other unions got for these same fiscal years. Other costs that were in the agreement is a senior step of 5% for any police officer who has been in the bargaining unit for more than 20 years, similar to what town meeting voted to fund for the fire in May of 2012. There's a night shift differential for last half officers, going from a 5.5% increase to 7%, a small increase and a differential for relief lieutenants. We had not had an increase for more than 15 years. And the creation of an EMT stipend. Since they are police or first responders, we wanted to incentivize more police officers to get their EMT certification. We also increased union days from 40 to 50, and we now have the use of Narcan that has been installed in all the cars. And we had a clean slate provision getting rid of some somewhat extraneous grievances. For FY 2015, and the most important thing we did in that year, in that contract, is that we removed civil service captains from the bargaining unit. The current civil service captains that we have now will be replaced through attrition, and we have created a new job called Deputy Superintendents. It is a management, non-union, non-civil service position, and I'm going to have the police chief expound upon that a little bit more. But this is something that the town and the police department has been looking for many years, and we were able to get it in this contract. And so for FY 2015 and 2016, we entered another contract as the first MOA was about to expire as we were signing it. So we have 2% increases for FY 15, FY 16, and another thing that we did, which was very creative, is to adopt an ed incentive that is similar to Quinn, in that it rewards certain, provides certain incentives for police officers to get educated. But the police chief had an interest in tying those incentives to the ranks. So an associate's gets, patrol officers will get an incentive if they have an associate's, bachelor's and a master's. Sergeants will get an incentive only if they have a bachelor's or above. And lieutenants and captains will get an incentive only if they have a master's or a JD. The other benefit of this ed incentive program that we've adopted is it is a flat dollar amount that's dispersed annually, but it is not going to increase as Quinn did with the growth of the payments. And so I think that's it. Chief, you want to talk a little bit about the deputies?
Thanks.
Thank you, Chief Leary.
Good evening. Dan O'Leary, the police chief. This round of negotiations took a considerable amount of time, and really it was done in order to get the best contract as possible that we thought for the town. I know that there's a senior step involved in here, which is 5%, in which in my 20 years as police chief, I have not seen 5% on the table for something like this. With that in mind, we wanted to make sure that we've used that opportunity to improve the police department, and we looked at a variety of ways of doing that. What we came to the unanimous conclusion with, the best way to do it was to change the upper management team. What we have fashioned as part of this agreement is that our current civil service captains, of which there are 4 of them, which are selected based on a written examination from civil service, that is now phased out if this contract is accepted by the town meeting. Once they're phased out, they're going to be replaced by non-civil service, non-union deputy superintendents who are selected from the rank of lieutenant. What this does is it allows the chief of police to form a management team that is directly responsible to him or her and has to be on the same page with them as they move the department forward. Right now, you don't necessarily have that option when you have civil service protections and civil service promotional opportunities only. This will allow a chief to select from, like I said, 10 lieutenants. It allows them to select based on their careers, based on what they've done over their careers and the kind of work ethic that they want to see in their command staff. This was the time to do it, not only because of the 5% being on the table, but also within the next 12 to 15 months, 2 of the current captains will be reaching the age of 65, and they will be retiring from the department, which allows this to start forming. We thought, as I said when I started talking here today, we thought the best way to improve the department was to work with the upper management, make them an appointed position, make them responsible for the work that they have to do, and responsible to the chief of police, the town administrator, and the board of selectmen. And this is the way that we thought was the best way to do it. So we hope that you support this contract.
Thank you, Ms. Daly. Yeah, you can be seated, Dr. Vitolo. I'll call on you.
Thank you, Nancy Daly for the Board of Selectmen. I won't go over everything that Sandra and the chief just said.
Thank you very much.
I just want to explain a couple things. One, under the current system, when those people get to the captain position, you have to take whoever scores the highest on the civil service exam. You can't look at whether they're actually a good leader or other factors that might make them the best candidate to run a section of the police department or not. That's why we feel like it's such a significant benefit to the town to get these positions out of that civil service testing scenario and into a merit system where the chief can select someone who overall has the best qualifications. On the educational incentive, Sandra mentioned Quinn, and some of you, I know many of you have been here for a long time, and you'll know exactly what that is. But the state used to have a system that the state shared with the town in providing this educational benefit for police officers, and the cost of that. The state finally eliminated the Quinn bill. Through our negotiations, we have protected the older police officers who were called Quinn eligible. They still get benefits for having achieved more educational, higher educational level, but the younger officers didn't have anything for a while there, and so this contract takes care of that. So we are happy with the 1.5% and 2% for the subsequent 4 years. That works out to be 2.52% a year, the total contract costs. And we voted unanimously for that. I also want to mention that we also settled with the emergency dispatchers, and that one is 2% in fiscal years 12, 13, and 14, each of those years. They also, for the first time, are going to be able to get an educational benefit for a bachelor's or master's degree in the fields that we thought were relevant. That's nursing, criminal justice, fire suppression, communications, or foreign language. They were desirous of having that benefit, and in return, they agreed to give up some personal days, 1 sick day a year, and their maximum number of vacation days, which was a little more generous than all the other contracts, is now going to be in line with the other contracts. The total cost of that package is 6.9% over the 3 years, and we voted unanimously for favorable action on that contract as well.
Thank you, Ms. Westfall.
Christine Westfall speaking for the Advisory Committee. The Advisory Committee spent a good deal of time discussing the 3 memorandums of agreement that are before you right now. Our concern always is to balance fairness to our employees against fiscal responsibility and to ensure that we have compensation packages that will allow us to continue to hire a caliber of employees that will allow us to function effectively in the town. We feel that these 3 agreements do that. We raised some concerns about pension liabilities, particularly with the increased salaries for the assistant superintendent positions, but we feel overall the management pluses far outweigh the costs in these particular memorandum. In addition, the memorandum are fully aligned with other contracts that we have supported for our employees, and we feel that this is probably as good as it gets in terms of management and efficiency. The Advisory Committee voted unanimously to support all 3 memorandums of agreement, the 2 that involve the police and the 1 that involves the dispatchers.
Thank you, Dr. Vitolo.
Tommy Vitolo, Town Meeting Member, Precinct 6. Mr. Moderator, I understand that at least one officer, Michael Grotman, has a PhD, and I wonder if there are any educational incentives for those officers who pilot higher and deeper.
Ms. DeBow?
So that captain in particular is a Quinn eligible captain, and he gets Quinn
But
eligible.
going forward,
But yes, I mean, I did a shortcut on the master's and the JD, but certainly if someone had a PhD, we don't open it up to all of the topics that you could get a PhD in, but there are some, if they are related to government and public safety, basically, you would get it.
thank you.
Ms. Carroll?
Carol, Precinct 10. My question has to do about the educational aspect of the police department's contract. And I think that you just answered Ms. LeBeau. I was interested in what fields police could apply for advanced degrees, and if there was regulations on that.
Mr. Bowe? Chief O'Leary?
There is a number of fields. Under the Quinn bill, the only time that you can get compensated is for a criminal justice degree or a law degree. We thought that it was important to get a college-educated police officer, really no matter what field that they were in. So we expanded the field by, I don't have the list in front of me, but it has to be by more than 10 different degrees that we would accept, as long as they are from accredited colleges across the country. We would accept their degrees as part of the new educational incentive plan.
Thank you, Mr. Margolis.
John Margolis, Precinct 7. I'd just like to know, under this contract, we're going to create the position of deputy superintendent. I'd like to know whether the chief's title will then be changed to superintendent, or are we going to have 4 deputies and no superintendent?
Chief?
The current rank structure in the police department has the chief of police, 1 superintendent, and 4 captains. So it would be, still remain the chief of police, 1 superintendent, and then the 4 deputy superintendents under them.
I apologize for my ignorance.
Thank you.
Thank you. On the first motion on page 2-18 relating to the police contract, those in favor, please raise your hands. Those opposed, raise your hands. Motion carries unanimously. On the motion on the bottom of page 2-18 relating to the emergency telecommunications dispatchers, those in favor, please raise your hands. Those opposed, motion carries unanimously. Article 3. The motion offered under Article 3 is on page 3-3 relating to adjustments in the FY15 budget, moved by Mr. Bors, seconded by Mr. Goldstein. Call on Mr. Bors.
Good evening, Harry Bors speaking on behalf of the Advisory Committee. Article 3 will amend our current budget in a couple of ways, by transferring existing funds between departments and by adding new funds. Now, each spring we vote on a budget appropriation, and that amount is predicated on a variety of assumptions, one of which is the amount of state aid Brookline will be getting. However, we don't know exactly what that number is at the time, and it isn't until the dust settles at the state level that we really have a hard number. That happens in the summer. So we adjust our budget when we come to it in the fall. Now, we tend to budget somewhat conservatively, and this is so that we can be pleasantly surprised rather than alarmingly disappointed, though we do try to be accurate as we can. As it turns out, we will be receiving an additional $38,850 in state aid from what we had originally assumed in our spring budget appropriation. Now, $38,850 may not seem like all that much in the context of an approximately $250 million budget, but these are meaningful dollars. You'll recall also in the spring that we established a new Department of Diversity, Inclusion, and Community Relations. And at the time, we noted that come this fall, now, we would need to make budget adjustments in order to fund that new department. Article 3 transfers $145,627 from the Health and Human Services Department, where the services had been provided, to the newly established department. Of the $38,500 in additional state aid, $15,368 is allocated to the school department, and $23,483 to the new Diversity, Inclusion, and Community Relations Department, along with that transfer of funds that I just mentioned. And with this, we will be able to fund our new department, putting it on a solid footing as it begins its important work that will reach across every department in this town. So the Advisory Committee unanimously recommends favorable action on warrant Article 3 as presented. And yes, we realize we had a typo in our write-up. Thank you.
Thank you, Mr. Goldstein. Ms. Daly?
Nancy Daly for the Board of Selectmen. We are in agreement with the Advisory Committee and voted unanimously to support Article 3.
On the motion on page 3-3, those in favor, please say aye. Aye. Those opposed, no. Motion carries unanimously. Article 4. The motion under Article 4 is on page 4-2. And there is an additional phrase that was, for some reason, omitted from the combined reports, but I'm assured was included in the motions passed by the Selectmen and Advisory Committee. And immediately after the word town in the 6th line of the motion at the bottom of page 4-2, please insert the words including but not limited to setting a value of not less than $1 for each such abandonment. That motion is made by Mr. Goldstein, seconded by Ms. Hummel. Mr. Goldstein.
Thank you, Mr. Moderator. Good evening, everybody. Ken Goldstein for the unanimous Board of Selectmen. Articles 4, 5, and 6 all relate to the pending redevelopment of the Circle Cinema site in Cleveland Circle. I'm sure many of you are familiar with it. As many of you also know, a small but critical portion of that site is located in Brookline. Most of it's in Boston, however. Several years ago, Brookline Town Meeting adopted a very far-sighted zoning bylaw amendment which maximizes Brookline's ability to control the future development of the site, while also practically assuring that there'll be substantial economic benefit from it. The site is tricky for many reasons. Most of it is in Boston, as I mentioned. It abuts the D line, one of the main means of egress from the site, an egress which is greatly favored if you want to minimize traffic impacts on Brookline, is over an easement which runs out the rear of the property and runs over land which is the property of the Waterworks condominium. The unit owners there are somewhat resistant to that plan. That's in Brighton, by the way. The site is also in close proximity to a few Brookline neighbors on Clinton Road whose backyards abut the MBTA easement and who will be visually impacted by this development more so than they were impacted by the Circle Cinema. After many, many years and many, many hours of effort, this project is finally at a stage where it is nearing a final regulatory approval from both Boston and from Brookline. The use, in case you're interested, will be a mix of hotel, high-end senior-only residences is the current plan, retail, and office. The Brookline portion will be only the office, hotel, and retail, no residences. Articles 4, 5, and 6 are some housekeeping matters to help ready the site for that development. Article 4, which we're talking about right now, relates to a sewer easement that's located in Brookline and runs across the end of Elliott Street through the rear of lots 405, 411, 419, and 433 Clinton Road, and then connects to an easement across the T right-of-way and ultimately across the Boston portion of the development site. The sewer pipe running through the easement has not been used by the town literally in decades, and we've confirmed that with our town engineers. Formally abandoning the easement will facilitate the development, but it will also result in a more effective screening for the 4 Clinton Road neighbors that are affected, because they won't have to worry about that easement as they consider plans for plantings, et cetera. So for this reason, the Board of Selectmen unanimously recommends favorable action on Article 4. Thank you.
Ms. Hummel?
Amy Hummel, Town Meeting Member from Precinct 12, speaking for the Advisory Committee. Thank you, Selectman Goldstein, for that excellent background on Article 4. For the advisory committee's part, the advisory committee was satisfied with the forensic work done by the DPW to ensure that the 15-inch sewer lines in question in Article 4 were no longer connected to existing town pipes. The Water and Sewer Division had told the committee that they had done a visual inspection and that the two sewers to confirm that they were no longer active, and noted that they would not serve any foreseeable future use for the town, having been abandoned in 1951 and being replaced by 21-inch sewer pipes elsewhere. The committee agreed as the development of the Cleveland Circle Cinema site moves forward. Abandoning the pipes and extinguishing these easements will free the town of any responsibility or liability related to the pipes or any excavating that may occur. The pipes are about 8+ feet down, so any excavating, again, will be done with the developers. And from the Economic Development Director, she did want us to also let you know this evening that the National Development has announced that they have formed a joint venture with the Boston Development Group and hope to start construction in 2015. Okay, so let's see. In conclusion, with the pipes and the easements long out of service and out of use, the advisory committee, by a vote of 23-0, recommends favorable action on the language voted on page 4-2, including the line that the moderator added.
Mr. Fisher?
Thank you, Mr. Moderator. Andrew Fisher, Precinct 13. Ms. Hummel made reference to a new partnership that the developer has engaged in. I wonder if this is an opportunity where I might ask whether the town meeting might be enlightened as to the status and progress of the development at the cinema site. Perhaps I could direct the question through the moderator to Ms. Bruton.
Yeah, Mr. Kleckner?
Could I ask Karen Bruton, our economic development?
Sure. Ms. Bruton?
So Kara Bruton, Economic Development for the town of Brookline. National Development did announce that they're going to do a joint venture partnership with Boston Development Group. They made this announcement yesterday, and kind of over the weekend, you'll see media announcements rolling out over the next week. The developers agreement that we already have with BDG will also affect any joint venture. So the agreement that the selectmen have signed, and that's part of the future article, Article 6, will be in effect as this moves forward.
Thank you, Mr. Davis.
Jonathan Davis, Precinct 10. Mr. Moderator, I believe Ms. Hummel had, if I heard her correctly, said that passing the article that would allow the abandonment of the easement would also relieve the town of liability with respect to the physical sewer pipes. And that seems to be, as I read page 6-3, to skip a little bit ahead, that I'm not sure that that doesn't seem to jibe with what 6-3 says, where it says that favorable action on Article 6 would empower the Board of Selectmen to negotiate the transfer and/or apportionment of liability to the appropriate parties. So I'm wondering if why those two, Ms. Hummel's statement and 6-3, don't seem to jibe, or am I misreading them entirely?
Yeah, call on Special Counsel Jennifer Gilbert to respond to you, Mr. Davis.
Thank you. Jennifer Gilbert, Special Town Council on Articles 4, 5, and 6. So the language in this vote allows the Board of Selectmen to release the easement. It will be abandoned in place. The pipes are not going to be removed, and the selectmen are only going to release these easements for the developer and for the neighbors on the condition that there is sufficient insurance as the project moves forward and the landscaping and other amenities are provided on top of that easement, and they'll make sure that the insurance and indemnity agreements are in place.
Thank you. On the motion on page 4-2 requiring a 2/3 vote, those in favor, please raise your hands. Those opposed? Motion carries unanimously. Article 5. Once again, we have some language that's been omitted in the combined reports, but that was included in the motions adopted by the selectmen and the advisory committee. At the end of this motion, at the bottom of page 5-2, which is the main motion under this article, please add the words, including but not limited to setting a value of not less than $1 for such release of claims. Motion is made by Mr. Goldstein and again seconded by Ms. Hummel. Mr. Goldstein.
Thank you. Ken Goldstein again. Very briefly, so Article 4 related to the portion of the sewer easement that was in Brookline. Article 5 relates to the portion of the sewer easement that's across the town line in Boston. So we need to not only give up our rights to our own sewer easement, but we have to give up our rights to send our sewage through Boston. So we recommend favorable action on Article 5 unanimously. Thank you.
Thank you, Ms. Hummel.
Amy Hummel, Town Meeting Member Precinct 12, speaking for the Advisory Committee. As this article dovetails with Article 5 dovetails with Article 4 and asks the town to release any rights and duties and responsibilities for a specific 18-inch sewer running through Boston and extending from the former railway property, which is referenced on the combined reports on page 5-3, if you want to look at the map. The committee was again satisfied that, like the two 15-inch sewer lines in Article 4, these were no longer active and no longer serve a useful purpose for the town of Brookline. So by a vote of 23-0, the committee recommends favorable action on the language voted on page 5-2, including the additional line.
Thank you. On the motion on page 5-2, those in favor, please say aye. Aye. Those opposed, no. Motion carries unanimously. Article 6. Motion is found on page 6-2 that the town authorized the selectmen to enter into agreements, pilot agreements with relating to the Cleveland Circle Cinema property, moved by Mr. Bors and seconded by Mr. Goldstein. Mr. Bors. Mr. Lynn Jones, sorry.
Thank you, Mr. Moderator. I am Sean Lynn Jones, speaking for Unanimous Advisory Committee. Warrant Article 6 is a companion article to Articles 4 and 5. It deals with the proposed development of the former Cleveland Circle Cinema site. You've already heard an update on the status of that development and some of the context for Article 6, including the provisions of Article 4 and 5. The important thing about Article 6 is that it pertains to the pilot and development agreements that the town entered into back in 2011 and amended in 2014. These agreements would ensure that tax revenues flow to the town from the property, even if it should be sold to a nonprofit entity. And they also dictated the minimum number of hotel rooms that would be located in Brookline. These are good agreements. They're well crafted and they serve the town's interests. But there may be additional agreements, and that's what Article 6 authorizes the Board of Selectmen to enter into. In particular, we've had some discussion already of the pipes and the sewer easement. Article 6 would also authorize the selectmen to enter into, for example, an escrow agreement that would be associated with the town's release of the sewer easement that runs through the property, as was explained by Special Town Council. The Unanimous Advisory Committee voted 24-0 with no abstentions for favorable action.
Thank you, Mr. Goldstein. Mr. Goldstein has nothing to add. On the motion on page 6-2, those in favor, please say aye. Aye. Those opposed, no. Motion carries unanimously. Article 7. And Dr. Coleman, would you please come forward, sit in the front row? The motion offered under Article 7 starts on page 7-6 over to page 7-10, relating to amendments in the town bylaw relating to the Brookline Commission for Women, moved by Ms. DeWitt, seconded by Ms. Khan. Is Dr. Coleman in the house? Oh, I'm sorry. Come forward, please.
Yes, I'm Alex Coleman. I am not a town meeting member, Tappan Street, Brookline. I'm the co-petitioner with the Board of Select People, and this is basically a follow-up article that responds to the resolution that was unanimously passed at the last town meeting, adding protections regarding gender identity and expression in Brookline. And that was very gratifying, and I had the opportunity to work very collegially with town council and with Dr. Gelano to come up with the places in the bylaws where the actual amendments would need to be put and to make specific recommendations. So basically what this does is it adds gender identity and expression to all the places where there are provisions for protections. The only place where there's a little bit different language is in relationship to the Commission on the Status of Women, and that was only made to clarify, recognizing that it's a somewhat different situation. Basically, as the advisory committee pointed out in their comments, there are a lot of places, as we were going through, where there are disparate applications of protections for different classes. And as a current member of the Lame Duck Human Relations Commission and an applicant for the new Diversity and Community and Inclusion and Community Relations Commission, I'm hopeful that that might be something that we could be addressing and bring before a future town meeting. So I hope you'll vote favorably. Thank you.
Thank you, Ms. DeWitt.
Betsy DeWitt speaking for the Board of Selectmen. Article 7 is jointly sponsored by the board and Dr. Coleman and is a direct implementation of Article 11 passed at the annual town meeting in May. That resolution affirmed Brookline's commitment to diversity and inclusion by prohibiting discrimination and harassment on the basis of gender identity and expression in employment, housing, public accommodations, credit and lending, and public education. In order to accomplish this, with the assistance of Town Council's office, the bylaws were reviewed in order to propose language changes that would make them consistent with this purpose. 5 sections of the bylaws were identified. I'm not going to give you their numbers, but they were the Brookline Commission for Women, the Human Resources Program Board and Office, the Fair Employment Practices with regard to contracts, the discrimination prohibition with regard to contracts, and the Fair Housing Bylaw. We all have the proposed language before us. The term women was further defined to include, quote, all women, whether by assignment at birth or by gender identity. And the phrase gender identity or gender expression has been added to the list of protected classes where they appear in the bylaws. It was not possible under the scope of Article 7 to review and update all of the named protected classes, and as Dr. Coleman pointed out, it was discovered that it's not consistent throughout all of our bylaws. However, in the future, it is not only desirable, but would be consistent with the intent of Articles 31 and Article 7 to create a single definition of protected classes for the bylaws that could be amended from time to time as needed. The Board of Selectmen unanimously recommends favorable action on the vote on page 7-6 of the combined reports.
Yes, just to correct what I said in my introduction, this actually involves the amendment of 5 different bylaws, and the titles are on those pages 7-6 through 7-10. Ms. Khan?
Janice Khan, town meeting member from Precinct 15, speaking for the advisory committee. So my job was made extremely easy since both Selectwoman DeWitt and Dr. Coleman referred to the advisory committee report. So I will just say that warrant Article 7 fulfills town meeting's May 2014 unanimous directive to town council to add language to the town's general bylaws to prohibit discrimination on the basis of gender identity and gender expression. And by a vote of 22 in favor with just one abstention, the Advisory Committee strongly recommends favorable action on this article. Thank you.
Mr. Bassett?
John Bassett, Precinct 6. Thank you, Mr. Moderator. Just a question. What does the phrase gender identity and gender expression mean?
Ms. Murphy, Town Council? Sure. Dr. Coleman?
There are no ignorant questions when it comes to this, and part of what will need to happen is a lot more education, so I'm glad you asked the question. Basically, gender identity is one's sense of who one is in terms of one's gender, man, woman, some admixture of that, boy, girl. One's gender expression is how you show the world what your identity is and how you feel inside.
Thank you very much.
Thank you. On the motion on page 7-6, over to page 7-10, those in favor, please say aye. Aye. Those opposed, no. Motion again carries unanimously. We will have some controversy here sooner or later. Article 8. The motion offered under Article 8 on page 8-6 over to the bottom of page 8-8 relating to the amendment of the bylaw provisions concerning disorderly behavior and disturbing the peace, moved by Mr. Green, seconded by Mr. Franco. Mr. Green.
Mr. Moderator?
Yes, Mr. Rosenthal.
I have a potential point of order. Marty Rosenthal, Precinct 9, co-chair of PAC.
Potential point of order. Yes, Mr. Rosenthal.
A suggested point of order. The advisory committee, the main motion, I think, is the advisory committee motion on beginning on 8-6. And I think, if I'm not mistaken, since I think I was the one that noticed it at the public hearing, the Scrivener's error mentioned in footnote 1 on page 8-5 is still a Scrivener's error on 8-6. Does anyone follow me yet? It's the provision that's renumbered 8.5.3, and the last reference to section 5.2b is supposed to say 5.1.
Okay, is that, okay, you're right. Thank you, Mr. Rosenthal, for pointing that out. In the paragraph entitled "Present to Disturb," whatever that means, about the next to last paragraph on page 8-6, change the reference from 5.2b to 8.5.1. With that correction, Mr. Green.
Bernard Green, Town Meeting Member, Precinct 7, for the Advisory Committee. Warrant Article 8 should not be controversial, although I think that there'll be some discussion following my presentation and the other presentations here.
Well, we'll see.
Those discussions will be good, because we really should understand why this warrant article is doing what it's doing. Warrant Article 8 amends Town Bylaw Article 8.5, which was amended in 2013. And the purpose of Warrant Article 8 is to fix certain provisions in Bylaw Article 8.5 that were considered to be constitutionally suspect in light of court decisions that limited the reach and enforceability of identical language in a state criminal statute addressing disorderly conduct. The citation for that, if anyone's interested, is Chapter 273, Section 53. Warrant Article 8 also makes some additional sort of refining changes to the bylaw article. And it basically cleans up the bylaw article as opposed to doing anything really major and substantial. Warrant Article 8 addresses the following changes to the bylaw article. Number one, the phrase, quote, makes offensively coarse, C-O-U-R-S-E, that's the other issue, utterance, gesture, or display, or addresses abusive language to any person that is in bylaw Article 8.5.1 has been held to be constitutionally overbroad and vague, and therefore it's been deleted. Number two, bylaw Article 8.5.3 has been deleted in its entirety for a number of reasons. First of all, the words offensive and annoy have been found by various courts to be unconstitutionally overbroad. Annoying someone can't be a basis for a criminal complaint. And as one court said, which I thought was kind of cool, one man's vulgarity is another man's lyric. There's also concern that language proscribing threats or annoying language directed to, quote, persons of the opposite sex, close quote, may violate the Massachusetts Equal Rights Amendment, according to dicta, which is a writing in a court case that is unrelated to the actual case itself, so therefore doesn't really have strong precedential value, but nonetheless indicates a potential problem with this language that we'd like to avoid. By deleting this section, section .3, in its entirety, we're also deleting language prescribing the use of disorderly language to threaten. And that's an important provision, but the advisory committee is satisfied, however, that that this issue is covered in the remaining bylaw article 8.5.1. In addition, the bylaw or the warrant article adds makes the following changes to sort of refine bylaw article 8.5. It adds disturbing the peace to the title of the bylaw, deletes the phrase quiet enjoyment from 8.5.1 as sort of inappropriate and confusing, and adds to 8.5.1 the following approximate language from a Supreme Judicial Court case to the effect, quote, this definition of disorderly conduct shall only relate to activities that involve no lawful exercise of a First Amendment right. So yelling about whoever you're yelling about on the street corner can't be a basis for criminal action. The advisory committee voted unanimously for favorable action on warrant article 8 with a minor scrivener's error that Marty discussed earlier. Thank you.
Thank you, Mr. Franco.
Ben Franco for the Board of Selectmen. Mr. Green did a great job summarizing the changes that this article proposes. I will simply add that there has been rumors that people feel as though some of these changes may make currently illegal or non-permissible behavior allowed. And the Board of Selectmen did an exhaustive review of the language changes and reviewed First Amendment interpretations and actually received a memo from Town Council's office which indicates that that is not going to be the case, that what is allowable today will remain allowable and what is illegal will remain illegal. The Board of Selectmen recommends favorable action on this article unanimously.
Thank you. Mr. Rosenthal?
Thank you, Mr. Moderator. I'm Marty Rosenthal, Precinct 9, and co-chair of Brookline PACs. I have a special interest in this bylaw for up and down reasons. I have a long history of disturbing the peace, at least as far as a lawyer goes.
At least in this auditorium.
I'm sorry, I didn't hear your comment, Mr. Moderator.
At least at town meeting.
Correct. In the early 1970s, a bunch of us young public defenders started challenging the disorderly conduct statute, and successfully, some of my colleagues. And then I brought the challenge to disturbing the peace under First Amendment grounds. And my case is cited in there, Orlando, page 8-4, and page 8-11, footnote 9. And the SJC said that my client, whose first name was David, was guilty, and the bylaw and the state statute always meant the following. And they kind of redefined it, in my opinion, but that's the SJC has a right to do that. But the point is that these two laws, disorderly conduct and disturbing the peace, tread very carefully to First Amendment protected activities. And there's a slew of cases that some of them are in your combined reports, more are in town council's bylaw, memorandum to the selectmen, that carefully try to walk this minefield. I then was on 1998, I believe, I can't swear to this, a committee chaired by David Turner revising all the town bylaws, and I was asleep at the switch and missed this one. And didn't call it to anyone's attention. And then 2013, when Stanley and Nancy added non-criminal enforcement, we made a statement saying, we're fine with that, but the bylaw needs to be looked at. And to their credit, the chief and town council's office, and Patty Correa especially, worked a lot on this and presented what you have before you, which I really welcome, and I commend them for doing it. It's much more carefully following the case law. I was at the advisory committee public hearing, and many people, well, a couple of people raised questions. What about this? What about that? Raising fact patterns that are legitimate questions, and everybody in this room could raise questions about real facts, hypothetical facts. Can't we do something about this? Can't we do something about that? Why doesn't this bylaw include it? You can't do too much with this bylaw. This bylaw, at most, should do what state law says is okay, but according to the SJC, and that's what town council and the chief have presented to you, is to put it in accordance with the SJC cases. It's really impossible to address the slew of fact patterns that people in this room can think of, some of them real incidents, with this bylaw. So I urge passage of this, and I commend the chief and town council's office for bringing it to us.
Thank you. On the motion on page 8-6. Oh, okay, Ms. Frawley.
Yes. Excuse me. In international law, definitions have zero weight. Neither does a mission statement. I don't know about domestic law, but I do.
Who are you?
My name is Regina Frawley. I'm from town meeting member from Precinct 16.
Thank you. I thought so.
And so the question is, what weight will, after this is gutted, and it's even gutted within the definition, what weight does definition have in domestic law? Because it has zero weight in international law. Not without an action section of laws to go with it to implement the definition.
I'm not sure I understand the question, but do you, Ms. Murphy?
So as a preliminary matter, I would like to acknowledge the very hard work of Associate Town Council Patty Correa in my office, who put a tremendous amount of work into this, and to acknowledge former Town Council Jennifer DePazzo, who put this on my bullet list before her departure to make these changes. But to Jocelyn Murphy, Town Council, to answer your question, Ms. Frawley, I think the statement that Ms. Frawley is making is that the definition alone can't be enforced. But the language in section 8.5.4, as it is proposed to be amended, resolves that issue and says that a violation of any of the provisions of 8.5.1 through 8.5.3 may be dealt with as a non-criminal disposition, refers to that section, which describes with particularity, as my predecessor speakers have said, what is not permitted under constitutional scrutiny.
Thank you, Ms. Liss.
I also have a comment to make before I leave.
Go ahead.
Abandon the microphone at this point. I did read the case studies, and while I also read the memo, there were two operative words in the juvenile case that would have been completely left aside by all the speakers, and that's the two words, comma, without more, comma. And in the dicta before that, in the description of the cases before that, it was all about whether there were accompanying threats that had loud, aggressive behavior, et cetera, et cetera. In other words, and witnesses were considered, and context and tone were considered. So it isn't that it's unconstitutional across the board, it's simply it doesn't cover all of this. It's that we cherry-picked and left out two very important words that would have allowed this to be legal. And I think we'll be looking at this again.
Thank you, Ms. Liss.
Lisa Liss, Precinct 2. Some language clarification, please, on 8.5.4, removal of graffiti. I'm just going to quote this, read this. If the Commissioner of Public Works or his designee determines that the graffiti cannot be safely removed, or that it is not appropriate for the town to remove it, he shall notify the property owner of his determination in writing, and the property owner shall remove the graffiti within 14 days of delivery. Well, if it's not safe, if the graffiti is not safe for the DPW to remove, how can it be safe for the individual homeowner to remove it?
Well, beats me. Ms. Murphy? I think that section of the bylaw was not focused on this go-around, but it's in the bylaw and it's before us, so can you answer her question?
Well, Jocelyn Murphy, Town Council, I'm willing to take a stab at it, though this is not language that is the subject of the warrant article. I believe that refers, and it's possible the Commissioner of Public Works can chime in here, but I believe that what that refers to is DPW workers on property, on ladders and things like that. I mean, obviously, we wouldn't want to enact a bylaw that puts our employees at risk.
Thank you. On the motion on page 8-6, those in favor, please raise your hands. Those opposed? Motion carries by a vote of 205 to 4. Are there any abstentions? And 2 abstentions. Article, I call for a motion to adjourn the regular fall special until we deal with the special within a special. Somebody make that motion, please. Is there a second? All in favor, please say aye. Those opposed, no. The regular fall special town meeting is adjourned, and I call to order the special town meeting with one article, and I acknowledge the proper posting and publication of the warrant for this special meeting, and call your attention to the motion being made under the only article in this town meeting on page 1-3 that the town approve the name of the athletic fields at the Cypress Street Playground to include the name of Thomas Hennessy. Moved by Mr. Spiegel and seconded by Ms. DeWitt. Mr. Spiegel.
Thank you, Mr. Moderator. Stanley Spiegel from Precinct 2 and speaking for the Advisory Committee. For those of you who don't know Tom Hennessy, for whom this honor is being proposed, and it's been almost 20 years, amazingly, since he sat at the selectmen's table. He was a rather special and super guy, a resident of the town, a citizen of the town. Let me tell you something about his background, which will help inform as to why this honor is appropriate. He was a star athlete at Brookline High School in 3 sports, track and field, basketball, and football. He started in football at Holy Cross College and played 2 years in for the then Boston Patriots, now New England Patriots. But then he pursued his career as an educator at Madison Park High School. Do I have that right? Yes. I do, thank you. Where he then became headmaster. And subsequently, he became headmaster at Boston High School, and he was serving there during the days of forced busing, a very contentious time where he did a superb job in keeping his students safe, their morale high, and their education continuing during that tough time. He, meanwhile, in Brookline civic life, was elected to the school committee, where he served from the late 60s through the mid-80s. And he was chair of the school committee during a very rocky time as well, right after the onset of Proposition 2.5, where the whole town, including the schools, had to make dramatic cuts. But yet, as chair of the school committee, he helped shepherd through these changes in a way that managed to preserve most of the wonderful educational reforms that were instituted by our legendary school superintendent, Bob Sperber, who I point out still serves the town. He's a town meeting member. He's sitting over there, and he's been a member of EDAB for many, many years. Bob is a great superintendent. And Tom was a great chair of the school committee during a very tough time. He also played an important role in the enforcement of Title IX, which that's a title which says that female athletes have to be afforded the same level of support as male athletes did, and he was a firm believer in that and in student athletics as well as in student academics. He was a very wonderful guy there. When he left the school committee, he became a town meeting member in 1990, and the following year was elected to the Board of Selectmen. And he served 2 terms and a year as chairman of the Board of Selectmen. And as far as anybody's been able to ascertain, he is the only person in the history of this town who served both as chair of the school committee and also as chair of the Board of Selectmen. His tenure on the board was also a contentious time. It was the time of the first Proposition 2.5 override that the town experienced, and he helped moderate and make for a successful override. He was noted, and by the way, others will tell you, fill in his background more than I can, but he was noted through his entire career as an athlete, but also as an educator and as a town servant, a public servant in the service of the town, for his being a straight shooter, a person never looking to grab headlines or accolades, just doing his job and doing it in the best interest of the town, not concerned about his own political advancement. This did not color his votes. He always let you know where he stood. He and I were actually not terribly close politically, especially on the contentious issue of rent control, where I was more strongly for it than he was, and maybe he was on the other side.
You have 1 minute, 1 minute, Mr. Spiegel.
I shall finish in that time, Mr. Moderator. But one always knew where he stood, and one always knew that he was as good as his word. So to sum up, as an athlete, as an educator, it is singularly appropriate for the field right across from the high school to be named in his honor. And the reason we're taking this up under Article 1 of the special town meeting is because it was originally proposed that there be a 10-year limitation, a sunset provision on this honor, because there was some concern as to whether he had enough of an association with parks to have this be a permanent naming change, even though the Park and Rec Commission had decided unanimously to support it. So the selectmen were appealed to and have instituted, called for a special town meeting which rids the motion 14 under the regular article, under the regular warrant, of this provision, which many of us found to be inappropriate and even offensive. And I would urge, and the advisory committee near unanimously, with just a few abstentions, urges favorable action on Article 1 of this special town meeting, and no action when we get to Article 14, on the assumption that Article 1 passes, which I have high confidence it will. Thank you very much.
Thank you, Mr. Allen. And Ms. Calico, would you please come forward and sit in the front row?
Thank you, Mr. Moderator. Members of the town meeting, my name is Bobby Allen. I'm a town meeting member from Precinct 16, and I'm honored to stand up here tonight on behalf of a number of people that have helped get us this far, to support voting in favor of the Cypress Street Playground to be named Thomas P. Hennessy Field at Cypress Street Playground. As Stanley explained, for procedural reasons, this special within a special was necessary in order to avoid the 10-year sunset provision, and a lot of thanks goes to Stanley for thinking this through. This has been supported by both Park and Rec and the naming committee. I want to thank former town clerk Jack Kendrick and other fellow BHS classmates of Tom for bringing this to light, and of course the current and past Board of Selectmen members for assisting carrying this through the process. Thanks also is due to the Park and Rec for ensuring that this proposal, and the naming committee for ensuring this proposal met the town policies and standards. I rise tonight for Tom because I owe all of my 25 years of public elected office, both as a town meeting member as a selectman, to Tom's advice and guidance. Now don't let that deter you from voting for this article. I was only 19 years old when I first ran for town meeting, and lost significantly. And Tom, I was driving around in my convertible. I had a little sign stuck in the convertible roof there to try to get people to vote for me, and it wasn't close. It was slates, it was rent control, and what does a 19-year-old know about that? Tom took me afterwards and said, "Kid, you did a good job. You know, I've known your family for a long time, and you hang in there, and you'll get elected eventually, and you're the future of this town." And I never forgot those words, and you know, to a certain degree, he put a little charge in my batteries to help me get where I wanted to go. So I have a lot to thank him. Now, Tom's accomplishments you heard from Stanley. You can read in the write-up, so I won't repeat them all, although they're very noteworthy, and I hope you do look at them. Distinguished athlete, town official, educator, but more important, great husband and a great role model for his kids. The 5 Hennessy boys grew up on Cypress Street, a short distance from this field that I hope soon bears his name. He later married his wife Mary and raised his family in Precinct 16. He raised 3 girls, Sarah, Tina, and Maria, all graduates of Baker and Brookline High, all who've went to Ivy League schools and excelled in athletics and academics, 2 are in their school's Hall of Fame, much like Tom is in this building's Hall of Fame. And again, as Stanley said, he goes down as one of the only Brookline officials to serve as both chair of school committee and board of selectmen. But more than anything else, more than anyone else I ever met, he did this with such humility. He rarely talked about his success or accomplishments and served in all his capacities with distinction and pride. Off the field, away from public service, Tom served as a mentor and teacher in a variety of arenas. You heard he was assistant dean of men at Holy Cross College, teacher and coach at Brighton High, first headmaster of Boston Madison Park and at Boston High. When I was in law school, Tom initiated a program at Boston High to have law students tutor certain classes and teach them basic legal principles as a way to help keep them motivated. At the time, that was a very, very troubled high school. It had very low graduation rates and huge dropout rates. But what struck me most is when Tom walked into the room, he did not command respect for the students and faculty solely because he was the headmaster. He commanded respect because he held everyone accountable and treated every one of those kids with respect. He looked to the faculty as members of a team of educators and held them accountable as a member of the team. He built his staff like a coach would build a team and found the best available educators to suit the need that he was looking for. And both faculty and student responded positively to this team approach, and the school benefited. While serving on both the school committee and the Board of Selectmen, people always knew where Tom was coming from. He was always going to do what he felt in his gut was in the best interest of the town. Sometimes this put Tom in direct conflict with the positions of lifelong friends, neighbors, and even other board members. But Tom stuck with his gut, and particularly when he felt it was for the greater good. He was always willing to stand accountable for his decision, never backing away or sitting on the fence, and never took the easy way out. More often than not, his decisions proved to be correct. But he was never a renegade. Tom looked at his other board members as a team. His style was to bring people together to discuss. And while I'm not saying he was easily swayed, he always gave people the time to speak and always listened. Too often in politics, you have people who are too busy thinking what they're going to say next to actually listen. That wasn't Tom. When I was first running for selectman, Tom's advice was never stay longer than 2 terms. His feeling was that there are a lot of talented people in this town, and the town benefits from having change. It didn't matter to Tom who would be running against him or if he shared that person's politics. He felt that change was in the best interest of the town in the long run. Now, I ended up not listening to him, and a few people over here ended up not listening to him. but always admired that he stuck to his conviction. It was probably why Tom was elected chair of both boards, because his fellow members supported his loyalty, his opinions, and his team approach to governing, and for that the town benefited. When Tom was serving as selectman, Precinct 16 town meeting members would gather before every town meeting and listen to Tom's insight on warrant articles and how and why the Selectmen Advisory Committee came up with their respective positions. He never really strayed from neighborhood issues because he viewed himself still part of that Precinct 16 town meeting team. And for that, we as town meeting members benefited. At his funeral, I got to meet many of his Brookline High teammates, Holy Cross teammates, and fellow educators. When talking about Tom, the reoccurring theme I heard was fairness, accountability, team player, motivator, fiercely loyal. That's when it occurred to me. I think Tom excelled so much in everything he did, athletics, education, politics, and family, because he approached everything like a coach approaches a team. Don't take the easy way out. Do your job and be accountable for the decisions you make. Rely on members of your team, for the team is stronger than any one individual. And if you follow these basic principles, then everyone can benefit. Tom clearly left a legacy in Brookline and Boston sports scene. He left a legacy as an educator, but his legacy to the town as a whole is clearly noteworthy. It seems appropriate to me to acknowledge this humble man whose commitment to public life and team approach made a positive impact on the town. There's an old saying, there's no I in team, and there was no I in Tom. Please support this article.
Thank you. Ms. Calico.
Good evening. I'm Donna Calico, and I have had the pleasure of serving you and the citizens of Brookline from 1992 to 2003 as a selectman, and prior to that, I was a member of the advisory committee and a town meeting member. It's a privilege to stand before you tonight and share some of my thoughts about Tom Hennessy as a public servant and my friend. On behalf of my former colleagues, Michael Merrill, Joe Geller and Bobby, we extend our thanks to the Park and Recreation Commission, the Naming Committee, the Advisory Committee, and in particular Stanley Spiegel, and the Board of Selectmen for their support of this article. You know, Tom has a long list of fans, but I had no idea how beloved he was to students, teachers, his colleagues on the school committee, and his long list of friends until I embarked on this public process journey. I'm going to expand a little bit about Tom's leadership and contributions during his 2 terms as selectman and 1 year as chairman, because I was with him during that time. I knew Tom since 1990 and served with him on the Board of Selectmen from 92 to 97 and built a friendship with him and Mary beyond his term in office. When I was elected to the Board of Selectmen in 1992, the town was in a fiscal crisis with a deficit. The statewide rent control issue was looming, and the potential retirement of town administrator Richard Leary was on the horizon, not unlike the real problems you are all facing today in Brookline. Tom was always prepared on every issue and never acted like a typical politician. He was decisive and thoughtful in defense of his positions he took, yet he delivered his remarks with a smile and a quip and a sense of empathy towards those affected. In '93, Tom was the decisive vote to hold off on rushing into a general override vote, wisely recognizing that more analysis was needed on this override question that only favored the schools, police, and fire. A citizens override committee was established that recommended capital infrastructure needs for the entire town, including significant funding for the Public Works and Parks Department, along with funding for schools and public safety. Some of you may remember from that era the phrase, the shabification of Brookline, and look how far you've come. On September of 1994, former town administrator Richard Leary retired after many years of outstanding service. A search committee and process were established. Suffice it to say that excellent candidates presented themselves well and were seriously considered during the hiring process. However, the politics and outside pressures divided the board. Tom, acting as chairman of the Board of Selectmen, had the fortitude to assess the facts and the character to personally inform each of the final candidates of his decision prior to the vote. On the following Tuesday, the Board of Selectmen unanimously selected Richard Kelleher as our next town administrator for 16 years. What followed were years of fiscal discipline, financial and capital planning, and reserve buildup. That paved the way for decades of good governance and organizational leadership, contributing to a robust open space and recreation program. Tom Hennessy was an exceptional individual, as you heard, whose character, courage, and leadership are worthy of this honor. His name is not a household name. His picture did not appear on the cover of People magazine, but his story is one each of us can tell our children and grandchildren, describing his leadership, teamwork, and integrity. He is one of Brookline's own. His athletic talents led him from fame to coaching. His education at Holy Cross led him from a degree to being a math teacher and a headmaster of Boston High School for 40 years. Peter Rowe tells me that he supervised by walking the halls with a clipboard in his hand. He did not seek higher office. He only was interested in serving the citizens on the school committee and Board of Selectmen. Tom Hennessy would have never wanted us to move forward with this honor. He was way too humble for that. But today we all can set the record straight about Tom and the example of his leadership and service, creating a legacy for all generations. Finally, we hope that this honor bestowed by the town will result in donations to support scholarships at Brookline High School and ultimately park maintenance needs. On behalf of my former colleagues and me, we urge you to vote favorable action on dedicating the fields at BHS as the Thomas P. Hennessy Athletic Fields at Cypress Street Playground. Thank you very much.
Thank you, Dr. Sperber.
Thank you, Mr. Moderator. Robert Sperber, Precinct 6. I want to thank Donna and Bobby and Mike and Joe and Stanley for taking the leadership on this important occasion. Tom Hennessy was elected to the school committee on 2 separate occasions while I was superintendent. First in 1969, and then again in 1980. And in his first term, he was an enthusiastic supporter of such innovations as K-12 curriculum development, equalizing expenditures among the 8 elementary schools, introducing occupational education, open campus, METCO, facing history, and the expansion of varsity athletics, particularly for girl students. He supported these innovations because he knew as an educator that these were important innovations for children. And it was based on his own leadership and experience in the Boston Public Schools. The second time he was elected was when we had to dismantle many of these programs due to Prop 2.5. And as chairman of the school committee, he took great care to do this with as little harm to children as possible. I'd like to make one final note. If the town meeting tonight votes in favor of naming the field in Tom's name, we will also be honoring the Hennessy family. Tom's father was a member of the school committee before he left to serve his country in World War II, and then Tom's mother took her husband's seat on the school committee. And Tom's brother Jim was a respected member of the Brookline faculty for over 40 years. So I urge you to vote in favor of this motion to name the fields in Tom's honor. Thank you.
Thank you, Mr. Witt. And Mr. Merrill, if you're here, would you come forward, please?
I'm Betsy DeWitt, speaking for unanimous Board of Selectmen. What is in a name? It's a fair question. What are the characteristics and qualifications for bestowing a permanent honor, naming a public space for an individual person? I believe Tommy Hennessy had them all. Leadership, integrity, commitment to fairness and equality, humility, and much more. He was an exemplary citizen, an educational leader, an independent thinker, and a thoughtful decision maker. I saw his leadership during the time he served on the school committee when I was PTO president at the old Lincoln School during the painful and difficult budget cutting after Prop 2.5 was passed. And later I chaired the advisory committee in 1994 when he chaired the Board of Selectmen. I saw how hard he worked to make sure that Brookline passed the first Proposition 2.5 override to address the town's serious overall financial crisis, and it also happened to include funding for increasing growth in school enrollment. Sound familiar, huh? In both cases, he was a powerful force and speaking for needs, and at the same time was calm, mostly, handling conflicts and also building coalitions. Tom was a role model for us all, a civic and educational leader, and an honest, decent human being. He loved Brookline, where he grew up and where he raised his family. He was an outstanding local athlete. What more could we ask in deciding to honor him by naming the Thomas P. Hennessy Fields at Cypress Street Playground? And by the way, it's a historic community park where in 1880 a running track was installed, and where over the years there have been track meets, baseball, and football games, the game he played so well. The unanimous Board of Selectmen recommends favorable action on Article 1 of the special town meeting and no action on Article 14.
On the motion on page 1-3, those in favor, please raise your hands. Those opposed, raise your hands. Motion carries by a vote of 208 to 1. I now call for a motion to dissolve the special town meeting within the special. Is there a second? Those in favor, please say aye. Thank you. Those opposed? I dissolve the special within the special, and we turn to Article 14.
Mr. Moderator?
Yes,
May I
ma'am.
have a point of personal privilege?
Well, let's have it.
I wonder if the moderator would give me permission, in terms of honoring individuals, to ask town meeting to congratulate one of our town meeting members, Deborah Goldberg, for being elected state treasurer.
I think you can. Congratulations to Ms. Goldberg.
Thank you, Mr. Moderator.
So I reconvene the regular fall special town meeting, and we turn to Article 14, which has been rendered moot by the passage of the vote you just took. So under Article 14, no action is moved by Mr. Bors, seconded by Ms. DeWitt. Those in favor, please say aye. Those opposed, no. Motion carries unanimously. 208 in favor and Mr. Friedman against. Article 9. The motion under Article 9, the only motion before you will be a motion to refer Article 9 to a Selectmen's Committee. It's found on page 9-12. It's moved by Mr. Bors and seconded by Ms. Daly. I call on Mr. Bors.
Good evening, Harry Bors speaking on behalf of the Advisory Committee. Article 9 proposes several changes or edits to the town's noise control bylaw 8.15. This article is not unfamiliar to most of us here. Now, while the committee felt that there was merit in some of the proposed changes, others presented some difficulty. There are 4 things that it seeks to do to define emergency generators. Emergency can be a somewhat subjective term. One man's emergency is another man's convenience. In fact, there are legal definitions. There are definitions within architecture, within building codes, and it probably makes sense for us to have a solid definition within the noise bylaw. It would also seek to permit the use of both the ANSI and the IEC standard sound meters. Right now, the town uses ANSI. We took a look at this and we thought, well, it's not prescribing one or the other, but it provides an option. We can debate features about it, and that's really sort of beside the point. There is a nuance in the mathematics in terms of the algorithm, how it does the calculation. That'll be meaningful to the mathematicians here. For the rest of us rabble, it probably doesn't amount to that much. Practically speaking, they both measure sound. It would also seek to define portable as it relates to leaf blowers. That was something we were not too convinced of, calling leaf blowers something that you can carry on your back. And then it would also define background noise levels at night. And this would be consistent with the existing definition that already appears elsewhere within our bylaws. Now, whether this is a right definition or not is a different discussion, but it does look at the issue of consistency, which was also important in our deliberations. So as the advisory committee discussed the proposed amendments, it became clear that the definition of portable leaf blower is problematic. And it prompts frequent discussions between landscapers and our town council. The town bylaws address leaf blowers in 2 separate sections, the noise bylaw and the leaf blower bylaw. And definitions are unclear, somewhat inconsistent, causing confusion among some property owners and the landscape maintenance firms. And this issue has been somewhat long-standing. The confusion between the 2 sections make it more difficult to enforce the town's expectations. And annually, town council and other departments receive phone calls from landscapers and others seeking to understand their obligations. Now, the article brings to light some standing inconsistencies in our bylaws, and it also provides proposes some meaningful changes. But there's a bit of work to do. We believe a selectmen's committee with a ready access to the relevant town staff may be able to address all of the amendments proposed under warrant Article 9 and recommend ways to develop clarity and consistency in our town bylaws. Therefore, the advisory committee unanimously recommends referral of warrant Article 9 to a selectmen's committee and asks that it develop clarity and consistency in the 2 sections of the town bylaws, noise control 8.15 and leaf blowers 8.31. Thank you.
Dr. Vitolo?
Tommy Vitolo, Town Meeting Member, Precinct 6. Town Meeting is no stranger to warrant articles related to noise. This is at least the 10th time we've discussed noise in as many years. And as Mr. Boers mentioned, town meeting is no stranger to this warrant article. Why? Because we saw it 6 months ago, word for word. Town meeting voted unanimously on this language in May, a vote of no action. That vote affirmed some simple facts. Nighttime noise isn't simply 10 decibels quieter than daytime noise, and the laws of physics really do trump the bylaws of Brookline. Neither the selectmen nor the finance committee recommended voting in favor of the petitioner's article this time around, and that's good, because the article still stinks. Town meeting is, however, being asked to refer this proposal, an article about European standards, rolling leaf blowers, electric generators, and day-night noise differentials, to a committee. Thing is, the language of the referral isn't about these things. The charge of the committee would be to, quote, review Article 8.15 of the town's bylaws for consistency, continuity, and clarification with other sections of the bylaws, including, but not limited to, Section 8.31, end quote. The charge of the committee is not about the language before us. It's not about enforcement or lack thereof. It's not about expanding the leaf blower prohibition. It's not about parties in North Brookline or summertime buzzing in South Brookline. It's about footnotes and cross-references. Are there sightings of landscapers and general contractors standing around in our community thumbing through the Brookline bylaws? Is this a thing? I doubt it. I suspect that tradesmen instead call the town, the DPW, the building department, even the police. What might a call sound like? These tradesmen call with a question, and a civil servant explains the rules as they apply to the issue in plain and simple language. No study committee will change the reality that it is town employees who communicate our expectations to contractors, not pages of legalese. No footnote will bring clarity to that conversation. This motion for referral won't solve a problem because there is no problem with the existing bylaw. The problem is the petitioner's warrant article. Treating a petitioner politely and with respect is an important and valued part of our local democracy. And as an occasional petitioner myself, I'm grateful for that. However, politeness should not manifest itself as a failure to vote no when a no vote is warranted. This town has real challenges that must be addressed over the next 6 months. Hancock Village, marijuana dispensary zoning and licensure, the Army Corps pulling out of the Muddy River project, school expansion, the override. Asking a handful of folks, including a member of the Board of Selectmen, to spend at least a half dozen meetings tinkering with language that tradesmen won't read in order to have no practical effect on the understanding or enforcement of the bylaw distracts us from far more important work. I believe that the Board of Selectmen and the Advisory Committee got it wrong 6 months ago by recommending favorable action on this very warrant article, and I believe they've gotten it wrong again by urging referral. I urge you to vote no on the motion to refer and no on the main motion. Thank you.
Well, the main motion is not
Excuse
before
me.
us, Dr.
Excuse me.
Vitolo. The only motion before us
Mr.
is...
Moderator, excuse me.
Just a minute, Ms. Frawley. The only motion before us is a motion to refer. Ms. Frawley,
Yes, very brief.
who are you?
I am Regina Frawley Still from South Brookline, and I live on Russet Road, where about 20 trees have been taken down accidentally or by deliberate due to damage to gas pipes. So at the risk of seeming frivolous or humorous, with the infrastructure that is so aged and ruining our trees in South Brookline and the high theft of our equipment right off our lawns, I think it's moot. I will vote against referral as well.
Well, thank you. Ms. Daly?
Nancy Daly for the Board of Selectmen. As Mr. Boers indicated, there are some discrepancies between the noise bylaw and the leaf blower bylaw. There's some issues about the generators, et cetera. So there are a few things that need to be cleaned up. We have already voted to set up the committee to look at this. Selectman Franco is going to chair that committee, and he's putting together some people with expertise in the area to serve on it. So we did vote for favorable action to refer, but even if you vote no action, we will continue to try to work on these things through our committee.
Thank you. Mr. Fisher? And Ms. Gilman, will you please come forward?
Thank you, Andrew Fisher, Precinct 13. As the proponent, or one of the proponents of the original leaf blower article, I think that what a leaf blower is a leaf blower, and the attempt by this article to limit a leaf blower to a portable leaf blower, and then define a portable leaf blower as something that only includes some portable leaf blowers, is what's called I think it's clear what it's called.
Well, Mr. Fisher, please, the article itself, or a motion in the words of the article, is not before us. All that's before us is a motion to refer. So please confine your remarks to the motion to refer, if you will. Thank you.
Okay, I don't think I have much more to add other than what, as to the motion to refer, that my good friend Dr. Vitolo hasn't already noted. We have better things to spend our time with.
Thank you. Ms. Gilman?
Jane Gilman, Precinct 3, speaking on behalf of the Green Caucus. Jane Gilman, Precinct 3, speaking on behalf of the Green Caucus. The Green Caucus recommends not to refer. We see no reason to refer this article to any committee. This article, as has been pointed out, is virtually identical to the article presented at the May 2014 meeting. That earlier article had the distinction of being unanimously rejected by us in town meeting. Noise pollution is an important issue in Brookline. This article is not worthy of our time. It is flawed, and voting to refer it is simply going to delay other business before us. The Green Caucus unanimously recommends not to refer.
On the motion to refer on page 9-12, those in favor, please raise your hands. Those opposed, motion fails. Article 10. And as you've heard, by the way, the intent of the referral vote is being carried out in any case by action of the selectmen, which they're perfectly able to take without direction from town meeting. Article 10. The motion offered under Article 10 is on page 10-4 over to page 10-5. It's moved by Mr. Franco, seconded by Mr. Boers, and there is a additional language that's found in the yellow supplement, page 2 of the yellow supplement. It's moved by Mr. Franco and seconded by Mr. Boers to add in the 6th line of section 8.16.3 at the bottom of page 10-4 the following. Regulations may also include temporary waiver provisions for cause. That will be taken as an amendment of the main motion. I call on Mr. Christ, the principal petitioner.
Hi, my name is Alan Christ. I'm a town meeting member from Precinct 4, and I'm the petitioner of warrant Article 10. Recycling is one of Brookline's most concrete markers of its commitment to sustainability. The town of Brookline has developed an extremely effective residential recycling program in the years since its creation, but the amount of recyclables collected through the residential program has plateaued in recent years. This begs the question of the next best step for the town in reducing its carbon footprint. Brookline's recycling program began in 1990 and applied only to recyclable materials collected by the town disposal service. In 2004, the bylaw was revised to include the private haulers, which often served larger apartment buildings. This change made recycling mandatory for all residential properties in Brookline, regardless of whether their waste was collected by the town or by a private hauler. However, the bylaw still did not apply to businesses, and the intent of warrant Article 10 is to improve the quantity and quality of Brookline's recycling product by requiring separation of trash and recycling on site for Brookline businesses. With this goal in mind, there are 4 critical points that I would like to make regarding business recycling. The first is that on-site separation will improve the town's compliance with the existing state waste ban. Currently, the state solid waste ban already regulates the disposal of recyclable materials such as aluminum, metal, glass, and paper. However, the state law does not require on-site separation of recycling from trash. It simply limits the amount of banned materials in any waste hauler's load, which arrives at a solid waste transfer station, to between 10 and 30% of that load. This approach runs into some difficulties with enforcement, as the transfer stations are not able to separate trash from recycling. This results in more rejected loads, which are often difficult to track back to particular businesses, because the waste haulers' loads often include materials from multiple municipalities that has been mixed. In addition, private waste haulers frequently do not separate the banned materials for disposal when on-site separation is not required, and this diminishes the quality and quantity of the recycling product. Warrant Article 10 intends to address this issue by requiring separation on-site for Brookline businesses. The second point I'd like to make is that the structure of the warrant article gives DPW and DPH the freedom to define business recycling regulations through an outreach process that has a fixed one-year timeline. The warrant article's intentionally minimal approach to revising the town's existing recycling bylaw will give DPH and DPW, who enforce the recycling law, more freedom to define regulations which they believe to be appropriate and fair, rather than taking a top-down approach which might not allow for adequate input from them. This process will allow DPW to reach out to the business community and define appropriate fines for business noncompliance, as well as potentially refining the guidelines for education and enforcement in the regulations. The third point I'd like to make is requiring business recycling has many precedents in Massachusetts. Communities such as Cambridge, Somerville, Hingham, and Northampton already require business recycling, and their bylaws and regulations include requirements for recycling collection, storage, education of local businesses, and the preparation of business recycling plans. And the fourth point is that passing warrant Article 10 will improve the community's health, environment, and quality of life. Increasing the recovery of recyclable materials from the commercial sector will directly reduce greenhouse gas emissions, while also reducing methane emissions in landfills. Additionally, the use of recycled materials can reduce greenhouse gas emissions and other pollution from multiple phases of product production. Business recycling is a program that is badly needed by the town and widely supported by many residents and businesses. When I speak to most people about the warrant article, people typically reply, business recycling isn't already required? That's really surprising. That should be a strong indication to the town that the time for this warrant article has come and is maybe even a little overdue.
Thank you, Mr. Franco.
Good evening, Ben Franco for the Board of Selectmen. Article 10 is a petitioned article that would expand the town's required recycling program to include commercial properties. The town of Brookline has for many years promoted recycling to minimize the amount of solid waste that enters the waste stream for both budgetary and environmental reasons. Examples of this effort include Brookline's successful move to single-stream recycling and the town's introduction of a requirement that residential properties recycle. The Board of Selectmen believes the next logical step in meeting the town's stated climate change and solid waste mitigation goals is to extend the recycling requirement to commercial properties. Requiring commercial recycling is not a new idea or one that was raised just this fall. Many of the communities that surround Brookline already require businesses to recycle, as Mr. Chris mentioned. Cambridge, Somerville, and Hingham, to cite just three. And mandated commercial recycling has been discussed informally since at least 2002 in Brookline, and specific mention of moving towards commercial recycling was included in the 2012 Climate Action Plan. So if the Board of Selectmen agrees with the petitioner that it is time to require Brookline businesses to recycle, why did we amend the article? The board inserted a provision that would allow for a temporary waiver to be issued when a property demonstrates its inability to comply with the commercial recycling program, the proposed recycling program. We did this because we understand that there may be cases where properties face logistical compliance challenges. Allowing for a temporary waiver, the length of which has yet to be determined, would allow for businesses to resolve the questions like where to store recycling containers and to work out a pickup schedule. The selectmen acknowledge that there is work to be done before commercial recycling can be implemented. The board believes that the one-year delay in implementation proposed in the article gives enough time for stakeholders and town staff to work together to write the necessary regulations and iron out the particulars. And the inclusion of a waiver provision provides a device that can be used to deal with any outliers not able to comply with the bylaw in fall of 2015. Inclusion of a waiver provision has led to successful implementation of similar articles in the past, the plastic bag ban most recently, and there is no reason to think that it would not lead to a successful result here. The selectmen recommend favorable action on Article 10 by a vote of 5-0.
Mr. Weiss?
Len Weiss, at-large member of the Advisory Committee. The Advisory Committee overwhelmingly supports increased commercial recycling at the source. Our initial referral recommendation was based on a lack of clarity regarding implementation, design and implementation. Excuse me. The revised language overcomes these concerns, and having recycled our thoughts, we now support the article.
Thank you, Mr. Richmond.
Clint Richmond, Precinct 6, and speaking for the Green Caucus. As has been discussed, everyone in the state is required to recycle under state law, and most businesses are already recycling. Businesses, on average, do generate more trash than residences, and we commend those businesses that are recycling. We heard from businesses during the process that they've been able to recycle and support this warrant article. However, many businesses are not, which is why this article is being brought forth. We've already heard a little bit of the history, but the Green Caucus has been discussing mandatory recycling since its inception in 2011. There have been surveys done with the business community about their thoughts on business recycling. The article originally proposed did not have this temporary waiver. We hope it'll be used sparingly, as it has been for plastic bags, and we hope it'll be temporary. There was some discussion at various points about a permanent exemption, which I think would be contrary to state law. We are not in favor of that, but we applaud the DPW and the petitioner and the Board of Selectmen for coming up with a compromise that I think will address any lingering concerns, and we support the article unanimously. Thank you.
Thank you. On the amendment, which would add the words, regulations may also include temporary waiver provisions for cause, after the word materials in the 6th line of 8.16.3. Those in favor, please say aye. Aye. Those opposed, no. Amendment passes. On the main motion as so amended, those in favor, please raise your hands. Those opposed, the motion passes unanimously. Now, you will recall that we postponed consideration of Article 11 until the first thing tomorrow evening, which brings us to Article 12. The procedural situation is a little bit complicated, so bear with me. The main motion under Article 12 is on page 12-9 over to the middle of page 12-10. It's moved by Ms. Hyatt. Is there a second to the main motion? Would someone? Okay. Motion is seconded. Ms. Goldsmith, seconded by Mr. Lewis, offers a motion to refer, which is found on the orange supplement, move to refer the subject matter of Article 12 to a moderator's committee to report back to the 2015 annual town meeting. Ms. Hyatt offers a motion on whatever color this supplement is, perhaps dark red, pink, fuchsia, on the fuchsia supplement. Ms. Hyatt would amend the referral motion of Ms. Goldsmith by adding to that referral motion the words, and to place a moratorium until the conclusion of the 2015 town meeting on all activity associated with the special permitting for any registered marijuana dispensary seeking to operate in Brookline, and that's seconded by Ms. Gross. This is a motion to amend of doubtful legality and enforceability, as I think will become clear in the course of the discussion, but it's not my function to keep from a vote motions that are made in good faith that are legally suspect. In any event, I call on Mr. Bennett, and he and Mr. Saltzman will have 12 minutes to present the main motion. And in the course of your presentations, I caution all speakers to address both the main motion and, if they wish, the motion to refer. Mr. Bennett.
Thank you, Mr. Moderator. Good evening. My name is Gordon Bennett. If you asked me on Memorial Day what my plans were for the fall, I can guarantee you this was not in them. My last stage appearance here was a jazz band concert in 1979. As some of you may know, I grew up on Monmouth Court. Weekend nights, when I wasn't playing the saxophone, we used to tap on shoulders in front of the liquor store on Beacon Street in St. Mary's. From there, we moved on to Amory Park, where we drank and smoked into the evening. I only speak about this now because I have the experience of growing up here in Brookline. I know the streets and I know the neighborhoods, and I know what it feels like to move from place to place. I know and remember how distance impacted where I tried to get beer and where I went to smoke. Physical proximity matters. Data shows it, and I can speak firsthand about it here in Brookline. Many have been touched by a loved one or a friend suffering through illness. I am no different. In 1994, my mother, Nan Bennett Kay of blessed memory, had been diagnosed with breast cancer. The chemotherapy regime was very difficult. She heard marijuana helped and turned to her friend for supply. I recall standing with her in a kitchen one cold winter's evening as she lit up and she passed the joint around. My mom lived another 7 years, passing away in 2001. The marijuana provided temporary relief at a very, very trying time. So why am I here tonight? This past June, an old Brookline friend who had moved to San Francisco was visiting. While our sons played across the street in Emerson Garden, I jokingly mentioned the proposed RMD. Roger didn't laugh. He simply said, "An RMD is no joking matter." And he continued on. There's a progressive community near where I live in San Francisco, just like Brookline. It welcomed one in, and within 2 years, the neighborhood collectively rallied to get rid of them. The increased crime, the street dealing and smoking, the double parking, the loitering, the littering, and the burglaries were too much. You should take this seriously, very seriously. And I did. The more I looked into it, the more concerned I became. The result of that chance conversation is warrant Article 12. Thank you.
The connection to the screen.
I'm sorry?
The connection to the display.
Have you consulted with the...
Yes, I told them
Okay.
I'd be presenting.
All right. So proceed. Let us know who you are.
Okay, my name is Dan Saltzman, and I do have a presentation. I was told that I would be able to connect the computer to it, so we'll... Yeah, that'd be great. Thank you, Gordon, for saying those words. I'm going to be speaking tonight about, I'm going to try to explain what's going on. I'll get into this briefly while we're waiting for the video hookup. The motion to refer to a moderator's committee, we actually think that, thank you. We actually think that it's a very good idea. It's very well intentioned. Let's see if this...
Mr. Moderator, point of order. I didn't catch
Mr.
Mr.
Davis?
Saltzman, Jonathan Davis, Precinct 10, excuse me. I didn't catch whether Mr. Saltzman is a town meeting member or...
He is not a town meeting member. You are a Brookline resident, are you not?
Yes, I live at 62 White Place, Brookline resident. So I'm here to explain what's happening tonight. I'm going to ask you to support Article 12. We have a motion to refer to a moderator's committee. I want to cite something from that motion because I think it's I agree with it completely. Through the months of discussing the zoning and location of RMDs with constituents and fellow town meeting members, it has become evident to us that despite our November 2013 vote in support of modification of state zoning, there remains much to be considered related to location and zoning of RMDs in Brookline. These are great points. Unfortunately, the motion can have no impact. There's no teeth to that. So while we support that idea, and while I think a study committee would be a great thing, without any enforceability, what we're asking is that you support warrant Article 12. It's the only way to protect all of Brookline. Warrant Article 12 protects all of Brookline. We do not support the motion to refer, and we're asking you to support Warrant Article 12. So why Warrant Article 12? Well, Brookline's RMD is a regional dispensary. Let's look at NETA's plans for their Brookline dispensary. There's 11 sales desks. There are 12 transactions per hour per desk. There's a capacity for 132 transactions per hour. That's nearly 35,000 per month. They've leased over nearly 10,000 square feet, which is 5 times larger than Newton's RMD. There's up to 10 ounces purchased every 2 months. 2% of the population will procure a medical marijuana prescription. Total prescriptions of at least 4,500, if not significantly more. We've all heard about what's happening in Boston. We just don't know what's going to happen. These are minimum numbers. So the projected minimum monthly sales is going to be well over $2 million. At least 450 pounds of marijuana will go into and leave the building. This is not a CVS. People have talked about that. We've heard about that for months, the idea that we don't care about CVS, why should we care about this? I completely agree. If this was being sold, if this was being distributed at CVS's and pharmacies, I wouldn't be here tonight. I think that would be a great thing, but that's not what this is. There's one dispensary, and it's going to be for hundreds of thousands of people. There's probably 1,000 CVS's in the area of Boston and Brookline and all the surrounding towns. It's the impact that it's the regional nature that produces the impact. So the regional size of operation produces a significant local impact. The traffic and parking, there's going to be thousands of customers coming from surrounding communities. The secondary market, and this is so important, diversion, NETA's own estimates are 18%. At least 18% of the marijuana that leaves the building will be diverted. That is a serious number. It doesn't mean that everybody going in and out is up to no good. That's not what we're saying. That's never what we've said. The vast majority of the people going into that building need to be in there, but there's going to be diversion. We know that. So how do we deal with it? Buffer zones. Buffer zones are conventional zoning tools that control exposure between uses and populations. They're used frequently at the local, the state, and the federal level. Studies show the greater the physical distance, the less the impact. We know that. Now, the state defaults, let's look at what Warrant Article 12 is compared to the state defaults and the federal law. And the federal law is really what's becoming very important, and this is something we just learned in the last few weeks. So the state standard, if you didn't adopt anything, this is what a town would end up with. It's 500 feet from schools, daycares, and facilities in which children commonly congregate. Now, Warrant Article 12 simply specifies playgrounds and parks with play structures as a way of making it more concrete. Facilities in which children commonly congregate was interpreted in a very strict way, and this is something that is much more concrete. It's too difficult to work with how in which children commonly congregate. The federal law, as enforced, the schoolyard statute, says that an RMD must be located more than 1,000 feet from schools, parks, and public housing. Again, we just found out about this a few weeks ago. But Warrant Article 12 produces essentially the same results as the federal schoolyard statute. The federal schoolyard statute is currently being enforced. If an RMD is cited within the schoolyard statute, we've seen that it will be closed down. The federal government, they're not enforcing possession laws. We know that. So we're not saying that, well, pot's illegal anyways. I mean, we know that. But they're not enforcing possession laws. What they're enforcing is the schoolyard statute. Warrant Article 12 ensures that Brookline RMDs do not violate federal law. The federal law is still being enforced. I can't stress it enough how important that is. The U.S. Department of Justice in August 2013 reaffirmed enforcement of the schoolyard statute. Emergency regulations were issued in Oregon. There were no dispensary shall open within 1,000 feet of schools. Hundreds of dispensaries were closed in Oregon, Colorado, California, Rhode Island, Washington, and Montana. Federal courts continue to uphold the Department of Justice enforcement actions in this area, as recently as this year. If we cite it within the schoolyard statute, it runs a very strong risk of being shut down. It would be incredibly irresponsible to do that. I want to bring your attention to an email to a town official. This was 2 weeks after the Department of Justice reaffirmed enforcement of the schoolyard statute. As you can see, it's September 16th, 2013, and it is from the current head of NETA. He says, "The Department of Justice reconfirmed the 1,000 feet from schools and playgrounds. It is unfortunate, especially in Brookline, but it is what it is. The federal government is reconfirming this." He goes on, "As we discussed, we are trying to identify a plan B for the bank building." Again, keep in mind, this is 2 months before town meeting last year. A plan B for the bank building is what they were talking about. Not straightforward, and we'll have something close to concrete, and we'll let you know.
You have 1 minute.
Okay, I want to bring your attention to what neighboring communities have done. Brookline is the only one in our neighboring area with anything less than the state standards. Everybody else has been more stringent. In 2013, Warrant Article 7 is what we were voting on here. Not me, I'm not a town meeting member, but the people here. There was a vision by the Zoning Bylaw Committee, and it was guided by a vision of an RMD that operated as a nondescript office within a larger building, possibly a medical office building, and that had no direct access to the street. Others may be concerned that RMDs will be prominent freestanding buildings, such as the Brookline Bank Building and Brookline
30
Village.
seconds.
Article 7, as submitted, attempts to address these concerns, but it didn't address these concerns. It fell short. Warrant Article 12 addresses these concerns. It allows dispensaries to be located in Brookline, over 275,000 square feet of land available. The last thing I want to bring to your attention, and I know we only have a few seconds, is a letter to Brookline on August 12th, 2013.
You please conclude, Mr. Saltzman.
This letter said that RMDs within 1,000 feet
I
of the
said,
school...
please conclude, sir.
I am concluding.
I'm sorry. We have a great many speakers signed up to speak, and I'm going to have to strictly enforce... Quickly.
Thank you, Mr. Moderator. I appreciate it. I think that this letter is so important because it says, and I'll just cut to the chase, this is a letter from, again, from the head of NETA, okay? And it says, we've adopted as a strict standard of care that we will not locate an RMD within 1,000 feet of a school. We bring this to your attention. We think only these companies that respect the federal 1,000-foot buffer zone satisfy important criteria. RMDs within 1,000 feet of a school are almost certain to be shut down. Nothing has changed. They're still enforcing this. Nothing has changed.
Okay.
To cite an
now
RMD,
you can conclude, Mr. Saltzman.
I would ask you to support Warrant Article
Thank you.
12.
Mr. Wyszynski? Yes, ladies and gentlemen, it's only fair to your fellow speakers to, when we have so many interested parties in this warrant article, to keep to your time limits. You all know what they are before you get up to the mic, and I'm afraid I'm going to enforce them, whether you like it or not. Go ahead, Mr. Wyszynski.
Neil Wyszynski for the Board of Selectmen. Article 12 will reduce the number of locations where a registered marijuana dispensary is permitted in Brookline. The proposal before you will allow RMDs in only 2 areas in town from the current 5. One of the areas is on Route 9 at the Newton border, across from the Chestnut Hill Superlux Theater, an area of extreme auto congestion and virtually no mass transit. The other is in the south part of Coolidge Corner, in the blocks where Trader Joe's, Faux Lemongrass, Lineage, Chef Chow's, and then extending into the surrounding area of apartment houses. Back when this zoning was passed, there was much discussion about what kinds of zones to allow RMDs, and we settled on general business, office, and industrial zones. In addition to school buffers, we considered whether to have a 500-foot buffer around playgrounds, daycare centers, and areas where children congregate. When we saw that after viewing the map, that this would have essentially eliminated RMDs from Brookline, and we saw we couldn't do it. The petitioner's proposal omits a buffer around areas where children congregate, thus leaving the two areas I described. The current zoning does, in fact, comply with state requirements. While the Brookline Bank site is the reason for this warrant article, this cannot be about and will have no practical effect on the Brookline Bank site. NETA has received final approval from the Mass DPH to proceed with local permitting and licensing process, and the owner of the site has filed what is known as an ANR, which effectively freezes the zoning on the site for the next 3 years. So whatever the vote is here, the permitting and licensing for the Brookline Bank site will proceed. So if this isn't about the Brookline Bank site, what is this about? This is about people getting the medical help they need. It's about having a site accessible by public transit. It's about patients who've been certified by their physicians as benefiting from medical marijuana having access to it. And while I can't stand up here and tell you that none of this product is going to get diverted to the street, I can describe how the product is going to be regulated. A real-time state database is going to be at the center of the process. Physicians and their specific medical marijuana patient recommendations will be registered in the database. Patients must also be registered separately to enter the RMD. At the RMD, the database will be accessed and the filling of the recommendation will be entered. Because all sales are entered in the database, the patient is prevented from double filling a recommendation. Law enforcement will also have access to the database on a case-by-case basis. This is very different from, say, California, where just about anyone can get a medical marijuana card, and yes, there have been abuses. This is a very different regulatory scheme. We've heard many concerns about RMDs, ranging from general concerns, concerns about the specific site, and concerns about the proposed operator. Some have said that this will be the only RMD in the urban part of the Boston region, generating hundreds of thousands of trips. I note that the first RMD for downtown Boston has recently been provisionally approved, and more for Boston is on its way. Many of the concerns are valid, which we share. We, like you, have concerns about security, hours of operation, traffic, product diversion, parking, and the integrity of the operator after the prior president misrepresented his academic credentials. We believe that many of these concerns can and will effectively be handled through the licensing process. The City of Newton has provided a good template for their RMD approval from which we'll build. They require patients to have an appointment, thus regulating the traffic and its flow to the site. The size of on-site sales are limited, with the overage to be delivered. Security detail requirements are specified, and there are look-back inspections. Whether the applicant likes it or not, we, the selectmen, are unanimous in our intent to use our licensing authority to impose the same kinds of rigorous conditions that Newton has imposed and more. Unlike Newton, however, Brookline will be imposing these kinds of conditions through licensing, which renews yearly and can be reviewed more frequently at the beginning and any time there are problems. This gives us and you, through a public process, the opportunity to evaluate whether the conditions are being met and whether there are negative impacts to the neighborhood. With respect to the referral motion, we agree with the desire to study RMD siting and learn from the experience, but we believe that the time to do it would be after we have some experience, that we have some experience and other communities in Massachusetts have some experience, not now. Let me end by asking, what if I told you that OxyContin, opioids, and perhaps worse were being sold across the street from the Pierce School? Would you be concerned? What if I then added that the dealer was Walgreens? With proper oversight, there can be little difference here. Let's not let our imaginations lose sight of who we're trying to help. We can do this right. We urge a no vote on the petitioner's motion and the referral and the Hyatt amendment, which we believe would have no effect.
Thank you, Mr. Lynn Jones.
Thank you, Mr. Moderator. I'm Sean Lynn Jones, Precinct 1, speaking for the Advisory Committee. The Advisory Committee spent a lot of time debating Article 12. We weighed the costs and the benefits, and in the end, we decided to join the Board of Selectmen, the Planning Board, the Zoning Bylaw Committee, the Advisory Committee on Public Health, and probably some other boards and commissions too, in voting no action, to recommend no action. And here's why. Number one, Article 12 dramatically reduces patient access to medical marijuana. As Mr. Wyszynski explained, the petitioner's motion would restrict RMDs to some very small areas of Brookline. It would become increasingly inconvenient for patients to have medical marijuana. It's unlikely, in some cases, that an RMD could even find a site that would be willing to rent space to them in those limited areas. If we care about patient access to medical marijuana, we should make it possible for them to have access here in Brookline. If we outsource medical marijuana to Newton, not only do we reduce that level of access and convenience, but we lose our ability to impose our regulations and to have control over the operations of any RMD located in Brookline. Number two, we felt that the negative consequences of RMDs, medical marijuana, have been greatly exaggerated. As Mr. Wyszynski pointed out, there will indeed be an RMD in Boston. The mayor has changed his position on that issue. There are also likely to be RMDs in Newton, Quincy, and other neighboring communities. It's unlikely that we will be overwhelmed by hordes of patients here. And even if we were, this would be an issue to be dealt with through licensing, not zoning. Because wherever an RMD was in Brookline, it would have the same problem if it were truly a regional dispensary. But through licensing instruments, we could reduce those negative consequences, if any. It's unlikely that there would be a problem with transfer of medical marijuana to children in daycare centers, because they are closely supervised. We probably don't need buffer zones around daycare centers. And as for diversion, Mr. Wyszynski summarized some of the state provisions that are based on experience in California and other states and impose much more stringent requirements. It also would be a felony to divert medical marijuana for illicit use, which might deter some patients who were tempted. I'd also point out that medical marijuana is often less potent than what you get on the street. It's tailored to treat specific conditions. The euphoria-inducing effects are less extreme, at least so I hear. And number three, the licensing process, as Mr. Wyszynski indicated, is the best way to deal with these consequences. We can follow the Newton model as much as possible, and we have the option of renewing or not renewing that license every year and expanding the regulations that we oppose. Just to touch on a couple of other issues that have come up. Remember, we're voting on zoning, not a particular applicant. We don't have to take as gospel what a particular applicant has said or done. We're looking to provide a long-term framework that would govern an RMD regardless of the operator. Regarding the enforcement of federal law, if you look closely at the guidelines promulgated in August 2013, they say discretion should be exercised when there is a state regulatory framework in place. And when the states are regulating marijuana, the federal government, DOJ need not enforce the federal law to the extent as it would if there were problems with those regulations. In addition, the risk due to federal law enforcement is borne by the operator, not by the town. If the operator feels that that risk is minimal, then that's their decision, just as any business has to confront risk. I'd even point out regarding federal law enforcement that the DOJ is now working to provide banking services to reduce the reliance on cash for RMDs, and that's been going on in 2014, which is a pretty high level of cooperation between the federal authorities and medical marijuana dispensaries. Regarding the Brookline Bank, which has been the focus of so much discussion, maybe it's not ideal. Maybe it wasn't what we imagined at the beginning. But the fact that it's a freestanding building and a former bank allows for a greater degree of security. It has on-site parking, and it couldn't be much closer to transit, which will facilitate access. Regarding the motions to refer, we discussed them this evening, and the advisory committee majority felt that there had been a fair amount of study already regarding zoning, and that licensing was the best approach to imposing additional regulations. Regarding the oft-mentioned state default guidelines, if you look closely, particularly at the Planning Board's report, the language of the state regulation says towns and cities should adopt their own regulations, and only if they don't do the state guidelines come into play. It's not a recommendation or a standard that's being imposed. It's a default if towns and cities can't be bothered. In the end, the advisory committee voted no action on every motion under Article 12 that was considered and that may be offered this evening. On the petitioner's motion, the vote was 25-1 with 1 abstention for no action. On the Goldsmith motion to refer, the vote was 16 in favor and 5 opposed for no action. And on the Hyatt amendment to the motion to refer, the vote for no action was 18-3 with no abstentions. Thank you.
Thank you, Mr. Vian, and Mr. Doggett, would you come forward and sit in the front row if you aren't already there? Mr. Bassett, you might as well have a seat. We're going to hear from 3 or 4 more speakers before we get to questions. Mr. Vian here? Yeah, come to the dais, please.
Thank you. My name is George Vienne. I live on Davis Avenue. I am not a town meeting member, but I am a petitioner, and I ask you to vote in favor of the petition. Like the other petitioners, I'm deeply rooted in Brookline. I've lived here most of my life since I was 8 years old. I went to the old Lincoln School, and I graduated from Brookline High School. My wife and I now raise our family on Davis Ave, and we have 3 small children. The main point I want to make about this warrant article is that it will protect the residents of Brookline, in particular the children, who are most at risk. And the people in Brookline who are most at risk are the people who live in public housing authorities, like 22 High Street, which is located right across the street from the Brookline Bank building. I know of what I speak because I grew up in a public housing project in Brookline. I grew up in the Chestnut Street projects down the point. The parents then and the parents now who live in the Brookline Housing Authority are consumed every day with trying to keep their children on the straight and narrow. And it isn't an easy job for them. There are no tutors, no internships, no friends in high places. Life for those people, as it was for me and my mother and my brother and my sister, is unforgiving. If you make one mistake, your life is changed forever, and there's no powerful person that's going to come out and help you. I've seen people destroyed by drugs. I've seen people destroyed by the drug trade. The younger brother of one of my best friends used to run heroin from Jamaica Plain to Brookline. And I saw what happened to him, and it wasn't pretty. Many of my friends felt the despair, the hopelessness, and the anger of what they saw every day. And many of them had their lives ruined and became drug addicts or led lives of marginal or petty criminality. Why would we want to make their lives more difficult by putting a marijuana dispensary across the street? The answer is money. NEDA is about making money. If they cared about the kids or the town, they would pick an appropriate site, appropriately scaled for the number of people who were really in need of medical marijuana. If they cared about getting people that medical marijuana they needed, they would pick an appropriate site so there was no controversy. So that everyone, I think, in this room would agree that people who need medical marijuana should get it. But this isn't about that. This is about them making money. In fleeting moments of honesty, Netta admitted they wanted to make millions of dollars at this site. They projected 18% diversion, meaning a robust black market would develop right across the street. People will walk across the street. They'll enlist children to sell marijuana for them. And what they will do is called fronting the drugs. They will give a kid an ounce of marijuana and say, come back on Tuesday and give me $400.
You have 1 minute, Mr. Vian.
And they've also said in one of those fleeting moments of honesty that locating an RMD within 1,000 feet of a school or a public housing project would be irresponsible. But money talks and their positions have changed. Netta is financed by a millionaire named Howard Kessler who lives in Florida and doesn't deign to come here and tell us what he's really up to.
You have 30 seconds.
And when we see this confluence, and Netta's also hired and enlisted people who are involved in state government who have now switched sides and now advocate for the very people they used to regulate. And when we see this kind of confluence of big money and political connections in Washington, we are disgusted. But it's happening right here.
Please conclude, sir.
And you have a choice, in my opinion.
No, please conclude.
I'm concluding.
Yep.
Between the paid advocates and the political consultants and the kids in the projects. And for once in my life, let the kids in the project win and support Article 12.
Thank you, Mr. Doggett. And Ms. Goldsmith, will you come forward, please?
Thank you, Mr. Moderator. John Doggett, Precinct 13. Could I have the first slide, please? I'd like you to look at these two town zoning maps. Shown in green are the areas where an RMD can be located. Does it come up? Thank you. The map on the left shows the impact of the current zoning, and the map on the right shows the effect of adding a buffer zone for the 89 daycare centers we have in town and the playground structures. As you can see, this would only leave two small areas, one in Coolidge Corner and one in Chestnut Hill. The addition of just one daycare center locating in each of those two areas would rule out an RMD in the entire town. This situation would put us potentially in violation of the State Attorney General's recent ruling. Next slide, please. That ruling, upheld by the Superior Court, says no municipality can use zoning to ban or effectively ban an RMD. And we are getting perilously close to effectively enacting a total ban on RMDs if we pass Article 12. Now let's take a look at the policy at the federal level. Next slide, please. The Cole Memorandum of August 2013 detailed a major shift in policy by the Department of Justice. In the memorandum, the DOJ makes the state the primary enforcer of marijuana policy, provided that the state has a robust controls on paper and is effective in practice. The DOJ will only intervene if there's evidence of criminal enterprise activity. Massachusetts has robust controls, and its law is primary and applies to RMDs, and consequently RMDs will not be targeted just for not conforming to federal buffer zones. Let's move on to more local concerns. Next slide, please. The number of patients and cars RMDs will generate, the proponents estimate that both will be overwhelming. Let's see why this is unlikely. Patient abuse and physician abuse contribute greatly to the large patient numbers in poorly regulated states such as California, Washington, and Colorado. Massachusetts regulations limit patient abuse. They require the patient's condition, and as a key example, I quote, "The condition has to be progressing to such an extent that one or more of the patient's major life activities is substantially limited." This is a high bar for patient certification. Physician abuse, as Selectman Wyszynski pointed out, it will also be limited, with all patient IDs and physician certificates being logged in real time and accessed by RMDs and potentially law enforcement. So let's take a look at the traffic which has been raised as a concern. It's everybody's favorite topic. Slide 5, please. We've heard widely divergent estimates of how busy this RMD will be. This bar chart compares the average number of customer visits per day for a bank with various estimates of daily RMD customer visits. Using standard traffic tables, a traffic engineer from Howard Stein Hudson estimated that the Brookline Bank would have generated about 767 customer visits, or that's about 500 cars a day. With 32,000 vehicles a day using Route 9, the contribution to the bank traffic is quite small. I calculated, using the various assumptions offered by NEDA and the proponents and the Brookline physicians, the daily customer visits of each of their scenarios offered. As you can see, all except one shows there will be fewer customers, therefore fewer cars than the bank handled when it was in operation. The outlier at the bottom magenta bar assumes Brookline is the only RMD serving the entire Boston Brookline population, and the DPH has already licensed 4 RMDs to share the load, so this scenario just will not occur. Slide 6, please. Article 12 specifies daycare buffer zones in which the real world provide no added protection for children. I think this slide says it all. We are a compassionate community, the great majority of whom, including the proponents of Article 12, are in favor of medical marijuana for legitimate patients. In the past 24 hours, we've been presented with a motion to refer and the moratorium amendment. I will pass over the next slide. Could you do this slide and just pass to the next one? Because I think the moratorium is amply being covered. We do not need...
You have 1 minute.
Thank you, Mr. Moderator. I believe we do not need a committee to further study the zoning options. Here's just some of the material that the planning department and the various bodies in town looked at in order to debate and look at the options that we have. The options are extremely limited, and as I've shown in the first slide, basically they come almost to none with this proposal of this Article 12. The communicated concerns that have been raised, such as traffic, security, procedures, RMD procedures, will get an adequate airing during the special licensing process, which has already been mentioned. So, a moratorium will...
Please conclude, Mr. Doggett.
In conclusion, I would urge no action on the amendment, no action on the motion, and no action on Article 12. Thank you.
Thank you, sir. Ms. Goldsmith?
Hi there, I'm Jennifer Goldsmith. I'm a town meeting member from Precinct 11, and can you hear me? No? Sorry. I'm Jennifer Goldsmith. I'm a town meeting member from Precinct 11, and along with Rebecca Mottner and Ken Lewis, we submitted a proposal to refer to Article 12 to a moderators committee, and I'll try to speak quickly. Let me just say this is an absolutely new process to me, so I just want... I appreciate your patience. I'm going to walk through the steps that brought me here, and I know many people in this room have spent many years, decades at town meeting, and so I'm just new on the conveyor belt here and appreciate your patience. The reason we submitted this article is really that we were trying to find a rational and probably what I would consider a more reflective approach to thinking about this important issue. And I think Article 12 is really kind of an imperfect proposal to a complicated problem. And I also just absolutely want to say I appreciate your comments, and especially Mr. Bien, really very compelling and heartfelt comments. Thank you for speaking so openly. So last November, we stood here, we approved a zoning proposal at the advice of town planners. We focused largely on buffer zones related to schools and daycares. Article 12 tries to bring those in closer conformity to the DPH recommendations. I think it's thoughtful, but it also misses a point of addressing possible broader issues for discussion. Yet voting down Article 12 is kind of a dead end, and it kind of said it's a dead end to more nuanced discussion around issues of RMD zoning. A moderators committee, I think, will allow us to be more imaginative and allow us to thoughtfully consider a range of issues related to RMDs and future proposals, and to bring well-considered recommendations back here in May. And I also want to say there's a proposed amendment to our motion. I'm not comfortable with it. Just to be clear, I'm not interested in halting the activities underway through this process. I think that we created a process that includes selectmen review and special permitting, and I think we have to trust that process and move forward and try to improve on kind of the narrow definition we set. So while the great can be the enemy of the good, in this case, I think stopping work in progress, doesn't make sense, but our zoning can just be plain better, and we need a conversation to do that. So here's how I got here. Earlier this year, a dispensary was proposed at the corner of Summit and Beacon, smack in the middle of Precinct 11. And I think that probably we can all agree in this room on one thing, that there's a lot of traffic in front of Anna's and Rod D. And that just didn't seem like a great place for something that was going to generate a lot of traffic. I provided information to the constituents and neighbors because I really cared about this. We were awaiting a traffic study. It never came about. I attended selectmen meetings, and I have to say really gained a much greater appreciation of the review process and the thoroughness that you guys apply, respectfully, our selectmen apply to this process. Ultimately, the Summit site passed by. I never got a straight answer. I think it had to do with the mortgage holding bank just not wanting it. And personally, for me, the issue kind of waned from interest. Not because I don't care, but it wasn't so immediate. The bottom line on the Summit Ave location for me, though, was that the rules we created last year didn't really address some of the most obvious issues. We didn't address traffic flow in a meaningful way. We didn't address a model that would think about something that didn't look like a retail storefront sufficiently, and I know a great deal of thought went into it, but somehow we didn't get to it. We tried to deal with daycare buffer zones. Daycares exist on like every corner in Brookline, so that doesn't seem like the right dividing line. A more valid concern might have been the presence of a storefront that many middle schoolers walk by every day. That's more relevant here. So I guess it struck me that we didn't really hit the right points necessarily in our zoning.
You have 1 minute.
I have 1 minute? Okay,
Yes.
I'll talk really fast. Okay, so the Route 9...
I don't know how you could talk any faster.
I can talk faster. Okay, so the Route 9 people had the same kinds of concerns. They came to me because I had been involved at the Summit location. I think that they care a lot. I think that they've had a trial by fire both through the process and through an extremely well-funded competitor. I have to say, getting a FedEx and mail on Saturday, I thought I left my car keys in New York at my parents' house. I didn't think it would be a lobbying envelope from Netta, and that sort of says to me there is so much money behind this. There's a lot of interest. But bottom line, we're talking about a new business activity. We can think about this more broadly. We can think smarter. We can think about vertical buffer zones, and maybe not so much thinking about schools and daycares. We can think about parking restrictions that look more like medical office buildings than general retail. We might think about limiting ourselves to one RMD in the town until we have some experience. We might think as someone on, did anyone get any email today about this? Anything? No? I got a lot of email today. No one on the listserv saw anything. There was one really interesting thing about how other towns are making...
Please conclude,
I'm
Ms.
right there.
Goldsmith.
Are thinking about how do they make this more financially viable for towns. Plymouth and, I can't read without my glasses, Plymouth and Quincy both came up with some really good ideas. So I feel like we can do more and better. Article 12 is thoughtful. It's not realistic. The proposed amendment to the Moderators Committee, I'm not sure it's legal. We made a choice as petitioners that it didn't make sense to attach to ours. And I just hope...
Okay, that's it, Ms. Goldsmith.
I hope you'll consider this concept as a way to keep the conversation going, which is important, bring good ideas back here, and...
Ms. Goldsmith.
Thank you, sir.
Ms. Hyatt?
I don't talk quite as fast. Angela Hyatt, Precinct 5. Although I'm on the advisory committee, I'm speaking as a town meeting member and a registered architect with 20 years of design and planning experience in the public sector. Some of you have come here tonight with your minds already made up, and many of you are tired about hearing about RMD zoning. I understand. You may believe that what we accomplished last fall is good enough, and that the concerns can be addressed as part of the special permitting and licensing processes that are still to come. As an architect, I realize that zoning may be a blunt instrument, but it is a primary tool for shaping our town. There are issues that can and must be resolved in zoning first before other tools. This is the very first page of our zoning bylaw, in fact, under the heading Purpose and Scope, provides absolute direction on this, saying, among other things, that our zoning is intended to encourage the most appropriate use of land, conserve the value of land and buildings, lessen the congestion of traffic. Here's why we need to hold our zoning to its own goals. First, regarding use. Is an RMD the most appropriate use for the old Brookline Bank building, which many consider an iconic gateway to Brookline? It is a single-use building, a far cry from the medical office building that was envisioned that you've heard about in our current bylaw, with its restrictive language regarding direct access from a public way. The bank is also squarely in the crosshairs, as you've heard, of 3 uses protected by the federal schoolyard statute: schools, playgrounds, and public housing projects. And hopefully today you were able to read the heartfelt letter from Jamie Colon, president of the Brookline Housing Authority Tenant Association, who sees this project as a, quote, threat to the economically challenged, the minority, the recovering, the at-risk who live in public housing. For these reasons, I believe the goal of encouraging the most appropriate use of land for an RMD has not been met. Second, there was a significant oversight last year in not considering the impact an RMD would have on conserving the value of adjacent land and buildings, one of the purposes. By the time an RMD opens at the Brookline Bank building, there will be a new tax-paying daycare center operating right next door. Will their business be affected by a controlled substance being sold a few feet away? Maybe. Although there seems to be some degree of disdain towards daycare centers in this town, I will say from personal experience that they are an absolute necessity to working families in our town, and they are a byproduct of our own economic success.
Now, Ms. Hyatt, you have less than 2 minutes left. I'm hoping you'll address your amendment of the referral motion before you're finished.
I'm going to address it at the very end.
Oh, better hurry.
Okay. Finally, thank you. Finally, the purpose of lessening the congestion of traffic at an RMD at Brookline Bank would fail this test on a regional, local, and even a micro scale. Even the zoning bylaw committee hadn't fully considered the effects this type of traffic would have when it failed to exclude local business districts in the original warrant language last fall. As part of the Planning and Regulation Subcommittee of the Advisory Committee, I take partial responsibility for the RMD zoning language in our current bylaw. Simply put, I don't think we got it right. Buffers are separate physical separations. Yep. You may be convinced that the daycare buffer doesn't make sense, and that playgrounds may sound more reasonable, playground buffers. We should start with those. We can always lessen them as we move forward, but it doesn't work the other way around. Once the RMD is in, it is in and grandfathered, and we have to work around it. So the motion to refer the incredible complex issue of this RMD to a moderators committee is an excellent idea in principle, but it does not address the Brookline Bank and its adjacent vulnerable populations. My amendment to this motion added a provision for a temporary moratorium, which we now understand is not enforceable. So therefore, I ask you to vote favorable action on warrant Article 12.
Thank you, Mr. Arbelez.
Mr. Moderator, ladies and gentlemen, good evening. Thank you, first of all, very much for having us here this evening and allowing us to...
Could you identify yourself and
yes,
your
sir, Mr. Moderator.
affiliation with NITA, please?
Absolutely. My name is Norton Arbelas. I'm a healthcare attorney, and I'm responsible for New England treatment and access standards and practices. Currently, 23 states and the District of Columbia have enacted medical marijuana laws, and indeed, all of New England has medical cannabis laws in place. The emergence of these regulatory frameworks, a clear shift nationally in public opinion, and the federal government's qualified deference to these new programs have effectively ended the debate over whether or not patients should continue to be criminalized and, more importantly, marginalized for the medical use of marijuana. Our state's 2012 medical marijuana initiative was approved by 75% of Brookline voters. And of the Commonwealth's 351 cities and towns, only 2 did not vote in the majority supporting the measure. This body, as we've heard tonight, 1 year ago amended the zoning bylaw to allow registered marijuana dispensaries to operate by special permit under an annual license granted by the Board of Selectmen and in locations that are at a minimum 500 feet from schools, while deliberately not adopting buffer zones around parks or daycare centers. Last year, like this year, the town's boards and committees considered the alternatives and decided to move forward with common sense regulations that are specific to Brookline and the needs of its residents. As cited in the advisory committee's supplemental recommendation this year, having an RMD in Brookline will not only maximize access for Brookline patients, but will ensure that the town's boards, commissions, and departments, including the selectmen, health, and police departments, will have the oversight and enforcement responsibilities over any such establishment. Despite nearly 2 years of thorough discussion by numerous boards and commissions, broad participation, and comments by scores of engaged residents, and a zoning bylaw and licensing process that continues to have the overwhelming support of residents and officials, a last-minute motion to refer has been brought before you. As good neighbors, we will continue to work with the town in any eventuality, though we respectfully submit that in the interest of effective governance, this body should address the merits of the warrant article and not kick the can down the road without any substantive policy justification. This issue has been honestly and exhaustively debated, and good governance principles advocate for legislative resolution. Indeed, since the beginning of this discussion 2 years ago, thousands of our state's residents have lost their lives to cancer, have suffered the debilitating symptoms of ALS and seizures and other life-altering chronic conditions without the opportunity to treat their illnesses with naturally based cannabis therapies. Simply put, it is time to act. After lengthy debate through a series of public hearings, as I mentioned, warrant Article 12 has been soundly rejected by the Planning Board, the Advisory Council on Public Health, the Zoning Bylaw Committee, the Board of Selectmen, the Economic Development Advisory Board, and the Advisory Committee itself. These recommendations of no action pivot around 3 major policy decisions. The first, the principle that the town has been given...
One minute, sir.
Yes, Mr. Moderator. A clear mandate by the voters to preserve safe access to medical marijuana. Second, that the supposed negative effects of RMDs have been exaggerated. And third, that a zoning bylaw amendment that in practice amounts to a de facto ban is the wrong vehicle to regulate these new entities. Regulated medical marijuana is new to Brookline, and understandably there is some apprehension. Let me take this opportunity to tell you that we are committed to operating a facility that is in the highest standards, that is in unambiguous compliance with the law, that we will be neighbors that can be counted on, that we will be responsive to community needs, and work with the town hand in hand through this process. All this being said, and of course, in the interest of patients and the fact that it is time to affront this problem and this issue face on, we urge you to support patient access and to vote no action on warrant Article 12 or any amendment that further and unnecessarily delays patient access. I thank you for your time.
Thank you. Now, we're going to hear from a couple more speakers. It's an important issue. Dr. Namey and Dr. Cohen, would you please come forward?
Thanks, Mr. Moderator, and thanks to the town meeting members. My name is Tim Namey, and I'm here to speak in favor of Article 12. I grew up in Brookline and currently live on Craftsland Road in Precinct 15 with my wife and 2 daughters. I'm a physician who's triple board certified in internal medicine, pediatrics, and preventive medicine. Also, I'm considered a national expert on substance abuse regulations and policy, and I previously served as a senior epidemiologist for the alcohol team at the Centers for Disease Control and Prevention in Atlanta. And in my current position at Boston Medical Center, I'm funded by NIH and CDC to study the effects of substance abuse policies, particularly on youth. I'm also supportive of treatments to make patients better, and I voted for the Medical Marijuana Initiative. But that initiative left most of the crucial details of medical marijuana regulation in our state to the DPH. And unfortunately, it is those regulations that drive my concern about our MMJ program and drive my support for Article 12. Despite DPH's strident and Shakespearean protestations that their regulations are in fact stringent, and despite the numerous testimonials from marijuana industry representatives that the state has set a new, quote, standard for medical marijuana regulation, the Massachusetts regulations are among the most dangerous in the country, particularly in terms of their potential to exacerbate the problem of medical marijuana diversion to youth. Let me be more specific. In the area of substance abuse policies, there are two things that really matter: the price and the physical availability of product. Lower prices mean more economic access to marijuana for youth and poor persons, and the state has not done a thing to control the price of medical marijuana. Prices will not be tied to those on the illicit market, and medical marijuana in Massachusetts will not be taxed. Furthermore, the state is allowing home cultivation or discounted pricing for anyone living with a household earning less than a staggering 300% of the poverty limit. And although this sounds laudable, it has the unfortunate side effect of increasing the economic availability to populations with the strongest economic rationale to divert to non-medical users or to adolescents. In states that have failed to control prices, typically marijuana prices have fallen by half or two-thirds. And with respect to physical availability, the state's notorious default limit of 10 ounces per 60 days, or between 10 and 12 joints daily, with the ability to request even more than that, is a national leader. Let's put this in comparison with other states that also have medical marijuana laws, which typically have possession limits that are 4 times less than our own. The more product, the more availability, and it will allow plenty of excess supply, even for heavy users, to potentially divert product and reap an economic windfall. Our 10-ounce limit is currently the highest among the 20 or so states that have not yet legalized marijuana, and in fact are 5 times the possession limit even in Colorado's medical marijuana program. And in Colorado, and this is prior to legalization, let's remember that 3/4 of youth in marijuana treatment programs were using diverted medical marijuana. So we're about to embark on a unique experiment in Massachusetts where our regulations are actually ideally suited to promote diversion to youth and to the non-medical market. Zoning ordinances are a crucial way to mitigate potential problems. First off, they are an effective way to limit diversion. Those are some of the highly effective physical availability policies I mentioned earlier.
You have 1 minute, sir.
But more than anything, they're perhaps the only way for our town to maintain control of a promising yet dangerous substance in the face of powerful economic operators and woefully inadequate state regulations. Our town cannot control the location of dispensaries. Cannot control the circumstances under which marijuana will be obtained, cannot control who will issue cards or under what circumstances, nor can it control how much marijuana will be dispensed or how potent it can be. But we can control the location and circumstance under which it will be maintained. And, and beyond the symbolic and social norms of having a large RMD and arguably the town's flagship location, let's not forget that physical proximity is the principal driving force behind the frequent shoulder tapping. So I urge town meeting members in conclusion to provide access to medical marijuana patients in need while minimizing the social harms that will never accrue to youth and our most vulnerable citizens. And these are exactly the kinds of situations that argue for more stringent zoning, not less stringent zoning. Thank you.
Thank you. Well, I'm going to take some questions. Ms. Hummel?
Thank you, Mr. Moderator. Amy Hummel, Town Meeting Member, Precinct 12. I'm curious as to, I know one thing regarding licensing that the selectmen and many town meeting members on the TMMA list seem to find appealing with Newton's licensing model was the option of patient, or the requirement that patients can receive an ounce, show up in person at an RMD, and then have subsequent amounts delivered. And it was unclear after the League of Women Voters TMMA meeting the other night that was something that NETA felt that they would be able to do here. Since it's something that many town meeting members and the selectmen seem to find a very positive, something that they wanted to do, I'd like to know if NETA feels that that is something that they would be willing to do in Brookline.
Mr. Wyszynski, do you want to respond? You're the licensing expert.
Neil Wyszynski, frankly, I think with respect to licensing, we'll hear from NETA whether they think this would be desirable for them. But I think the Board of Selectmen are going to be making a decision on that and all the other licensing provisions independently. So if we think that is a desirable model, that's the way we're going to vote.
Mr. Bassett?
Thank you, Mr. Moderator. John Bassett, Precinct 6. I have several questions. Angela Hyatt said, I think, that because she's been told that the amendment on the magenta sheet, the amendment to the referral motion calling for a moratorium is not enforceable, that she is urging favorable action on Article 12. So my first question is this amendment to the referral motion going to be voted on?
Well, we're going to put it to a vote, Mr. Bassett. There were other sponsors than just Ms. Hyatt.
Okay, thank you. Is there a possibility of there being more than one dispensary in Brookline? My memory is that last year we were told that the state has set aside a certain number of provisional licenses per county, and I think that's limited. Is that right?
I think we're allowed 2. Is that right, Mr. Wyszynski?
5 per county. 5 per county.
5 per county.
Okay, well, they probably won't all be here. Then how does buffering work if a dispensary gets there first? So we have a dispensary in Coolidge Corner, and then somebody wants to locate a daycare center close to it. Would that daycare center license be denied? Are we also regulating children's facilities if we regulate?
No, I think it only works one way, Mr. Bassett. If the dispensary is already entitled to be where they're located, the daycare center can move within that radius. I believe that's the way it works.
Okay, and last, what would be, maybe a question for you, what would be the function of a moderator's committee if, as Selectman Wyszynski has said, the approval has been granted, the zoning has been grandfathered? The question really now is going before the selectmen.
Well, that's an interesting question, Mr. Bassett. The motion is to refer the subject matter of the article to a moderator's committee. The subject matter is zoning as regards RMDs, and moderators' committees have typically, I charge the moderators' committees and then get out of their way. They typically set their own agenda, and the scope of their inquiry is pretty much up to the chair and the members of the moderators' committee, so I can't really predict how a particular moderator's committee will go about its business.
Thank you.
Ms. Khan?
Yes, Janice Khan from Precinct 15. So I have a comment followed by a question. The current warrant Article 12 was generated by our neighbors in Brookline Village. The current amendment to one of them to refer to a moderators committee was put on by our neighbors in Washington Square area. And another one was put on by neighbors in Brookline Village all the way through town. It's not just the proponents of this of the Hyatt amendment were not just our neighbors in Brookline Village. And so while we as a community support RMDs for all the right reasons, we are a compassionate community, my guess is that any neighborhood would react in the same worried way. This is an unknown in Brookline. We have no experience in Brookline or, frankly, in Massachusetts. We have no way to know exactly how these state regs will really work within a community. And I would support any measure to move more slowly in Brookline. Maybe this is not the time to be on the leading edge of this smoking, banning smoking in restaurants. Fine, that was nice that Brookline led the way, but maybe caution is the way we should go. And so my question is that I'd like clarified: if the state licenses the RMDs, what local regulatory powers do local authorities actually have over the RMDs? I presume they don't de-license, the state licenses. But yet I hear people saying that the BOS, the Board of Selectmen, licenses the RMDs. So I'd like some clarity as to what this actually means in terms of local control. What sort of regulatory power does the Board of Selectmen actually have regarding RMDs? And what sorts of regulations can the Board of Selectmen actually impose? Thank you.
Ms. DeWitt? I think we've heard a lot of comments about that, Ms. Khan, but Ms. DeWitt?
Sorry, I co-chair.
Who are you?
Sorry, Betsy DeWitt, Board of Selectmen, and I co-chair the town's licensing review committee and have done for a number of years with Selectman Goldstein. We have on our calendar for December 11th a review of existing regulatory schemes for RMDs. We are consulting closely with Town Council's office. Patty Correa is doing a lot of research into this. And I will tell you, I personally fully intend to totally and completely regulate and license this facility and the operations. I believe we have the power and the authority to treat it as something between a pharmacy and a medical office. I believe that we can require appointments. I believe that we can require regular reporting about how many visitors there are per day. I think we have additional powers that may or may not be best addressed through zoning, but we certainly will use our regulatory powers. We will demand reports. We may limit the types of cannabis products that are offered. We can control a lot of aspects of this operation. I don't think we can give you anything now other than an expression of intent, which is unanimous amongst the Board of Selectmen, that we will regulate and we will license. And I will be pursuing it over the next couple of months. And I hope that we'll have better answers in the spring. By that time, we should have something before the Board of Selectmen, presumably. It has to be done within the period that the RMD proposes to open. So springtime is more or less our deadline.
Thank you. Mr. Davis?
Jonathan Davis, Precinct 10. Mr. Moderator, I have two legal questions that I hope will get some legal answers. First, is it correct to say that if Article 12 passes, that nevertheless the RMD at the Brookline Bank building can nevertheless go forward?
You've heard that stated by Mr. Wyszynski, and I believe that is the case.
Thank you. Second legal question. I've heard that the Hyatt amendment on the pink sheet, if it were to pass, would nevertheless be unlawful and unenforceable. Can we have a very brief explanation of why that is so?
Well, it's because it's an attempt to impose a zoning regulation without going through the statutory requirements for zoning. I think that's Town Council's view of the situation.
It's not it's referring
it's imposing the imposition of a moratorium on the progress of zoning is at least, or perhaps I should have Town Council articulate this.
Thank you.
Thought I was going pretty good there for a minute.
Good evening, Jocelyn Murphy, Town Council. Mr. Moderator, you are doing an exceptional job, and I'm happy to supplant your comments. What the moderator has said is correct. A moratorium is considered under case law, has been interpreted as being in the nature of a zoning amendment, and there is a very strict statutory scheme that must be followed in order for a zoning amendment to be imposed. It requires a number of steps, including public hearings, and a report from the planning board and so on.
Thank you.
Thank you.
Yes, ma'am.
Rebecca Plout-Mountner, a town meeting member from Precinct 11 and co-petitioner with Jen Goldsmith and Ken Lewis on the motion to refer. I just wanted to address Mr. Bassett's question. As has been clarified, our motion to refer would not affect the current proposal for Brookline Bank, but since there are 5 licenses available in Norfolk County, and Brookline is an attractive location because of its public transportation access and proximity to the medical area, it's quite possible that another RMD will be proposed in the near future, perhaps even before we have much experience with the operation of a facility at Brookline Bank, and therefore we think it's worthwhile, based on all that we have learned in the last 12 months, to delve a little deeper and perhaps revise. Perhaps the committee would, or some members on the committee would, for the next town meeting, propose revisions or refinements to the zoning bylaw that we approved last year that would put us in better stead for any future applications.
Thank you. Yes, sir.
Thank you, Mr. Moderator. Brian Hochleitner, town meeting member from Precinct 6. I have a question. The Boston Globe ran an article approximately 2 weeks ago in which they detailed efforts by towns that are being considered as potential sites for RMDs to enter into consensual agreements with the operators as a condition to granting permits, in which the town would collect revenue based on, in most cases, the gross sales of the RMDs. And my question is, and I'll just, so the examples were, Quincy is going to get 3% of gross, Plymouth will get $300,000 a year, plus they're trying to get the ability to charge a 5% excise tax, and Brockton will get 3% of gross sales, plus 1% of gross sales that will be given to nonprofits in the town. And I didn't hear Brookline mentioned there, and I'm pretty sure it's not because we've got so much money that we don't know what to, we don't want any extra. I know there's an override on the agenda very soon, and so my question is, what, if anything, has Brookline done to look into this? Is this something that I've heard a lot of talk about, all the regulations that are going to come as part of the licensing process? I'd like to hear a
Well, I
little
think
bit about
your
that.
question is, will a system of that kind of compensation be on the table during the licensing process? And the answer, I assume, is yes. Yes.
Okay.
Thank you, Ms. Carroll.
Mary Elise,
I'm
Precinct
sorry,
6.
Mary Elise.
That's all right.
It's getting late.
I'd like to speak in regard to the motion to refer, and I draw on the experience that my neighborhood had in regard to the red cab site on Route 9. At the time that a special committee, Davis Path Study Committee, was formed, the parcel was in fact frozen, much as we've been told that the situation at the Brookline Bank has been frozen. But that committee did its work, and the long-term result was very, very positive. And it seemed as if it was doing its work in the face of an impossibility. And I would like to suggest that a motion to refer, even though, again, it may be facing what seems to be an impossibility, should proceed, because in the long run, the results might benefit the neighborhood and the town.
Mr. Madison.
Hugh Madison, Precinct 5. I'm wondering if the Department of Public Health or the Police Department have Any comments to make on this on enforceability?
Enforceability of what?
Distribution? Distribution on the streets, or do they have any sense of this location being a problem?
Is Chief O'Leary still here? You have a lot of patience, Chief. You heard the question?
Dan O'Leary, the Chief of Police. In response to that question, no matter where an RMD is located in the town of Brookline, I would be concerned about the location. And I think that our participation in the licensing scheme that's going to go through the town is going to be critical. I think that we have met with this group on a couple of occasions when they were planning their site to be at Summit Ave and Beacon, and they had some really good ideas and they're responsive to some of the requests that we had, but I think that it can be better addressed, and we should wait to do it through the licensing, and we're all on the same page as far as that's concerned.
Thank you. Ms. Jonas?
Elisa Jonas, Precinct 16. I have two questions. One is, if doing the motion to refer with the added motion to freeze is not legal, could we reverse it? Is it too late to do voting on Article 12 with a motion to refer as well, to kind of get around that
Well, let me
option?
explain how we're going to go about the voting. We will first vote on Ms. Hyatt's amendment to the motion to refer. We will then vote on the motion to refer either as amended or not as amended, depending upon how Ms. Hyatt's motion fares. If the motion to refer succeeds, that will conclude our proceedings under Article 12. If it fails, we'll get to the main motion. Does that answer your question? I hope.
I was just wondering if there's a way to do it with voting for Article 12 with a motion to refer added to it. No, that's not possible. Okay.
Motion to refer is a separate matter that prevents us from getting to the main motion.
Right. And I guess I've also kind of been swayed a little bit since the advisory committee meeting on this, and I can see us going slower rather than faster, given all the questions we have. So I am wondering if maybe the petitioners could let us know what the advantage would be voting for Article 12 when apparently the
No, I'm not going to try to get an answer to that question.
Could Council Murphy explain?
You've heard the statements that have been made by the petitioners and those in favor of the main motion.
No, but there's a reason why they're still pursuing that, even though we've been told that it's not going to have an impact on NETA. Is there a legal explanation behind that?
Ms. Jonas, you were told by the principal petitioner that they are not in favor of a motion to refer. They want to vote
No, I'm
on-
not talking about motion to refer. I'm just talking about the article itself. Article 12, we've been told, will not prevent NETA from locating at the Brookline Bank building, and yet that's the primary reason currently for them pursuing it. And I'm wondering, is there what is the legal reason behind wanting to pursue Article 12 to accomplish that?
Well,
do you not understand what I'm saying either?
may fail of its original, at least
No,
one of
all
its
right.
original purposes.
It's okay. I'll pass.
Well, I'm going to entertain a motion for the question.
I'm still at the microphone, sir.
Yeah, I see you're at the microphone, Ms. Frawley. How can I miss you?
I wouldn't want to take it personally.
So, is there a second to the motion for the question? Okay, let me tell you, you see Ms. Frawley and Ms. Wentz at the microphones. I have the following people signed up to speak in favor of the main motion. Mr. Greco, who's a Brookline High School student. Mr. Selwyn, Susan Healy, who's a Brookline Village business owner. Mr. Hochleitner, Mr. Knight, Diana Post, who's a Precinct 5 resident, and Elizabeth Childs, who's a Precinct 5 resident. I have the following people signed up to speak against the main motion and against the referral, presumably. Mr. Hyken for the Planning Board, Dr. Cohen for the Public Health Advisory Council, Dr. Eisenberg, who's not a town meeting member, Mr. Levitan, and Ms. Epstein, who is not a town meeting member. Against that background, I will take the motion for the question. Those in favor of calling the question, terminating
Can I
the
ask
debate.
for a recorded vote on this? Motion
Recorded vote
to
on.
call the question.
Well, if there are 35 people that want a recorded vote on a motion for the question, we'll have one. But I don't see 35. I suppose if we waited the rest of the night, we might get it, but no. No, we'll not have a recorded vote on the motion for the question. So on the motion for the question requiring a two-thirds vote, those in favor, please raise your hands. Those opposed? That motion carries by a two-thirds vote. Now, as I explained to Ms. Jonas, we will start with Ms. Hyatt's motion to amend the motion to refer by appending a provision for a moratorium. This takes a majority vote. Those in favor of Ms. Hyatt's amendment, please raise your hands. Those opposed, motion fails. On the motion for referral, Ms. Goldsmith, unamended.
I would like to call for a recorded vote on this.
Okay, if there are 35 town meeting members who would like to have a recorded vote, we will have one. And there certainly are. This is on entitled Article 12 Referral Motion. And one comment, if you think your vote has not been properly recorded, please see the town clerk. Yep. Okay, here we go. Those in favor of the motion to refer, please stand and press 1. Those opposed, please stand and press 2. Those, you can abstain at any time, you can change your vote at any time. Motion fails by a vote of 65 in favor, 138 against, and 5 abstentions. Which brings us to the main motion, which is the motion on page 12-9.
I'd like to ask for a recorded vote on this.
Well, if there are 35 town meeting members who would like a recorded vote, and there are, what's this very same 35? This is Article 12, main motion. Remember that your vote will not be recorded unless you push either 1, 2, or 3. The numbers, the buttons numbered 1, 2, or 3. Okay, we'll start the... Okay, those in favor, please stand. Press 1. Those opposed, please stand and press 2. And if you wish to abstain, press 3. Motion fails with 60 votes in favor, 146 against, and 10 abstentions. I will take a motion to adjourn. Article 13 will be the next one. I have 4 or 5 speakers who want to be heard, even though the motion is for no action. So I'll take a motion to adjourn town meeting until tomorrow evening at 7 o'clock. Is there a second? All those in favor, please say aye. Those opposed, no. Town meeting is adjourned until 7 o'clock tomorrow evening. Thank you, ladies and gentlemen.